Sorry, how he knows it. I'm
Sure.
just asking if he told me that.
Right.
So I wasn't asking how he knew that. I wasn't asking the source of that knowledge. I was asking if he told me that.
Sure.
That was it.
But that's the point. It's how he knows it.
Right.
The source of his knowledge. The state would contend is hearsay because it's gossip and innuendo, which is what was indicated the last year.
Well, it may not be hearsay. It may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her. And I think we need to figure that out before we can go any further.
Yes, and if the source of the information is a witness who've testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline or when it occurred. That was one of the first questions that Ms. Murphy asked.
I didn't ask when. I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first got knowledge of that.
Okay. So if the question is, when did you first get knowledge? I think we can start there.
That was the question. Yes.
All right.
Thank you. When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you first gain knowledge? I didn't ask the source of the knowledge, didn't ask you to comment on the validity of the knowledge. I asked when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. You can answer that.
Just for the record, I appreciate your honesty. But he said he has no personal knowledge, so it's clear he had to gain the knowledge, not from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right? And that's what we got to get to.
It's evident this is going to go nowhere. I'm convinced it's going to go nowhere.
Apologize.
When did
We're
you
back
first
where we
get
started
knowledge?
from.
I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
I don't know how to answer that. I mean, so I can't give you a date if you're asking for a
Oh
date.
my God.
If you're asking me, how did I get the knowledge?
Oh my
It would have
gosh.
come directly from a client.
Right.
No.
So help me understand.
I think you say you can't answer that question. You don't know the date. So that's the answer to the question.
But I said that 5 minutes ago.
We have to make it clear.
Yes.
Fine. Next question, Ms. Merchant.
So you don't know the specific date.
Who cares about the
Do you
date?
know-
When's the first time
okay,
you saw
okay,
him?
Can we narrow down the timeline? Did you gain knowledge in 2019 of this relationship beginning?
I'm going to object to this line of questioning as he said he does not know
Sure.
when he gained
All right.
knowledge.
He doesn't know
Overrule-
the specific
That's
date.
fine, Ms. Merchant. I think I'm overruling that. I think we can try to see if he can narrow it down based on goalposts.
Just kick him off the stand. That's really what they're going for anyway.
19, I would probably say no. I mean, I don't have anything that there wasn't a specific date. There wasn't a football game. There wasn't something that I can attribute to him telling me whatever.
Then why
And
did
so
you tell
You're
her?
asking for a date. You're
It
asking
happened
for
before
a year.
then.
It's still a date. And at this time, I am telling you
Hey,
that I
everybody.
do not have
Welcome, welcome.
the date.
Let's try this then. So you received a contract from Ms. Willis, January 2021, correct?
Can I see the?
Yes,
Boy.
Yes, I think so.
Exhibits are, I think, okay.
I think
And-
if it was from the exhibits, I think it was 21. Yes.
And I don't want to belabor the point. You submitted those
Yes.
when you were here before.
Yes.
If those documents that you looked at last time
Yes.
said January 2022, that's okay.
21.
I'm sorry, 21. You're right. Thank
And
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was, that we have in the record is January 25th, 2022. So using that date, at that point, had they begun their romantic relationship?
Of 2022.
January 25th, 2022, 2021, I'm sorry. When you got your first contract?
You guys, I've got to stop it because I know exactly where this is headed. I think you guys do too. He was sequestered or in an interview with the judge yesterday, and they've already strategized how not to answer the questions. This is a waste of time. Let's go ahead and continue.
I don't recall, any specific dates.
That's Rico lingo for I'm not answering it.
You remember when you got that contract, though, correct?
I remember I had the contract, yes.
Okay. And you told us last week, or I guess it was the week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
That is correct.
So Ms. Willis is not the one that brought that contract to you directly. It was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship, though,
I'm
correct?
gonna object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing specific.
He doesn't remember the exact date. I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly
Sure.
what he just said. This is
All
asked and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here, but he answered that last question. So what's your next one?
And Judge, I didn't hear the answer if they were in a relationship January 25th,
Mr.
2021.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes.
You knew her through the business. So you had met her prior to your contract?
I'm gonna object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now. And so I'm trying to create a timeline to hopefully piece this together.
All right. Well, I'm not seeing really the likelihood that that's going
Oh
to have
my
any success.
God, it's like
I'll let you
pulling
ask a few more
teeth with
questions, but if
pliers.
it doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you.
Put a 1 in the chat if you guys can hear me.
So the time that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
Yes.
Okay, and so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm gonna object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that
Sure.
he rarely saw them together, but this was
Yeah,
answered.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially through, well, actually, no, if he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong,
Knowledge that was conveyed to him by,
by somebody else. That's that he claimed at the time was privilege. I found that it's not. That's what we're here to explore.
okay. Do you remember telling me that not many people knew where they met?
I'm gonna object as to relevance, as to his personal knowledge, which is what 602 requires.
Yeah, I mean, we're back to the same point, Ms. Merchant.
His personal knowledge is what I'm asking him what he told me.
But he hasn't yet told you how he knows that. And so unless he can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next
him.
that would be the next question. But
Ask him how he knows it.
I first have to establish that he said that.
No, you don't. You could go the other way around.
When you told me that it started when she left the DA's office and was a judge in South Fulton, where did you gain that knowledge from?
Well, I'm gonna object because his testimony a few minutes ago is that he did not recall making that statement.
All right, I'll overrule that. Mr. Bradley, answer the question if you can.
Repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
I was speculating. I didn't have a No one told me I was speculating.
No one told you that?
No one told me.
What'd you base the
You were speculating
speculation
on
off
things
of?
that had been told to you or things you had observed?
So I'm going to object as to the nature of this line of questioning because the witness has made it clear he was speculating as to how or what he knew. And if it's speculation, it's inadmissible for this court.
All right, but the motivations for his reason for speculating would be admissible, so I'll overrule that.
Thank you, Judge. Was this speculation, when you told me that, was that based on things that had been told to you and things that you had witnessed?
I never witnessed anything. So, it was speculation. I can't tell you anything specific if that's what you're asking.
You can't tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no.
This big meatball is sitting his round behind up here, pretending like he don't know nothing because he thinks there's going to be some salvation for him sitting his meatball head up here, acting like he does not know, and he's already going to be trashed. He is collateral damage, and it makes me upset.
I don't.
Did you have any reason to lie?
It really does. He's not going to give anybody any answers.
I don't know if speculation is lying, but
Well, let me just show me where in this text it says you're speculating.
you didn't ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here. that
No,
this is
it-
speculation.
If this is the same one that you just showed me, it does not.
And you're welcome if you need to look at your text. Is there anywhere in here that indicates that you didn't have knowledge of the
No.
relationship?
Your Honor, I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. He's explored that. He said it's speculation and he didn't get it from any source other than his own speculation.
Sure,
So
I think we're flushing that out, and I think it's her right to have a little leeway on this if he's an adverse witness.
Thank you, Judge. And Judge, these speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I
What?
object and take offense to that comment. I'm objecting based on the law, and I'm making a record for the court. So I take offense to that comment. It's not the case.
All right, well, I think we can start with objection, the grounds, and the rule number, and then if I need more, I'll ask.
Thank you.
All right.
Thank you. What did Nathan tell you about the relationship?
Objection, hearsay.
Nathan has testified. It's
Yeah.
not hearsay.
It's still hearsay. It's an out-of-court statement being brought in for the truth of the matter asserted. So hearsay.
Judge,
Yeah, this would be for impeachment by contradiction, which would
Thank
be an
you.
exception to the hearsay rule, and admissible as substantive evidence, and the privilege issues are overruled.
thank you, Judge.
Well, I think you just overruled the privilege objection, but we don't know when he's talking about. So we've already established that December 2018 was the date of the privilege.
Sure, and that's something I covered in the in-camera hearing, and I'm, based on what he told me in that in-camera hearing, I don't believe any statements to this effect were covered by privilege.
And Judge, I just want for the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object. And they're clearly
Absolutely
interacting
he
somehow
is.
in the court. So I just want the record to reflect that because it wouldn't otherwise.
It's there now.
Thank
Do you have a question was put to you, Mr. Bradley?
Judge, one of my lawyers is sitting right in the back, that's
We don't have to go
behind.
down that rabbit hole. You can look wherever you want.
And there's the
And I've
other
never
meatball.
Looked at Mr. Wade or his attorneys. That sounds true.
All right. Mr. Bradley, question was put to you.
Repeat the question, please.
Yes. So I showed you, or I asked you, I'm sorry, the last question I asked you was, what did Nathan Wade tell you about the relationship?
Same objection, Your Honor.
And that's already been ruled upon.
I recall him stating that at some point they were dating. I can't tell you what date that was. It was made in confidence. We were in the back of our office. Our offices were the only two in the back. There was no one else present. That is all I can tell you at this time.
One time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
No, I think that's clarify for their own sifting cross. Ms. Merchant.
I do not recall any other time that he mentioned that they were in a relationship. No.
You may not.
Hey, you guys, welcome in. We're watching this meatball
So other than.
make
we
a
talked about
mockery
this
of
one
the
time,
court system
and you
here.
said you don't know when it was though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not recall.
And how did it come up?
Say again.
How did it come up?
I do not recall how it came up. It was in the back. I know where it occurred. In our offices in the back. I can't tell you what we were discussing prior to that.
Did you receive an email from me on January 6th with a motion attached?
I think I did. Yes. Yes. I know I received I don't know if the date is January 6th, but yes, I received that.
Okay.
Yes.
So you remember receiving that,
Yes.
the date? Okay. And you reviewed it, and then you and I spoke about it. You recall that?
Did we speak over the phone or are you saying through a text?
That's what I'm asking you. If you
I
recall
can't
speaking.
remember whether it was text or phone or
But you recall us speaking, one way or another.
one way or another. Yes.
And where I was trying to confirm the facts in that filing.
I think I remember there was a line of about the accuracy of how much money that my office, the law office of Terrence A. Bradley, have received, and whether or not that was going to be in the motion or not.
Well, there wasn't a discrepancy. I had kept that out, and you asked me to put that back in, correct?
I recall you that may be accurate, yes.
And you thought, because you thought it might be suspicious if you were left out of the motion.
No, I think we discussed that it should reflect the accuracy because the accuracy was that I received, I had a contract and received 74,000. And I think you had put in there that Mr. Campbell had received a certain amount. And then you also had put in there that Mr. Wade had received a certain amount, but there was not anything in there originally. And I said that it needed to be accurate. I needed to be accurate as far as that I had received 74,000. That's
Right.
correct.
Because you did not want anyone knowing that you had talked to me.
I would object this for relevance.
Be biased. Overruled.
I wanted you to be accurate as far as the accuracy of our message or your filing.
Okay, so that was your interest was in accuracy in the file.
I didn't reach out to you and say, send me a copy of your motion.
Right.
I didn't reach out to you to say that I'm going to be in your motion.
Right. I asked you to review it for accuracy.
For accuracy. And I just stated that it was inaccurate.
And the inaccuracy that you pointed out was the thing about your salary or how much you had made.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out when you had put
Okay.
the firm, the money wise. I did not, when I responded to that, it was for that specific reason.
Okay. And I agreed I would put that back in, that section back in, and I did.
Correct.
I did put it back in, and I sent it to you again.
I don't recall getting a second email from you, no.
But you were happy that I put it back in, or that I agreed to put it back in.
And object this to relevance.
Yeah, we need to get to more material aspects.
Yes, Judge, I'm moving along, I promise. So you did ask me to put that back in.
Well,
And answered relevance.
well, you didn't answer that last question, so overruled.
You did, can you confirm you did ask me to put that back in, for it to be accurate?
Yes, that's correct. I said that, yes.
Okay. And then I asked you if everything was accurate, and you said, looks good. Correct?
I recall you asking that, but the looks good was applying to the accuracy of the 74,000. That's it.
Okay. So when you reviewed the motion and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion though, correct?
No, I did not.
And that motion alleged that their relationship began when Ms. Willis was in municipal court.
If I can reread the motion, but I don't recall, but if that's what it says. But I did my saying that it looks good was when you put back in the 74,000 into your motion.
Okay, and that wasn't what I was asking. What I was asking is, you didn't tell me that there was anything else inaccurate in the motion though, right?
But I didn't state that anything was accurate other than the 74,000.
Now, when I told you that I had this motion that I was preparing, you asked me to send a rough draft.
No, that's incorrect.
May I approach, Judge?
You may.
Which page are you showing?
They're not page numbered. It's January 6th. Yeah, of course. I can show you just all the text. Look and see if this one. So, we had been talking and you asked me to send you a rough draft and I told you, okay, but I didn't want it to be leaked before I filed it. Right?
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
Yes, that's correct. Yeah, yes, that's correct.
And that was at 10:08 on Saturday, January 6th. And then you got an email from me with that rough draft at 10:25 that same day, correct?
Yes.
If you need to look at it,
If it says 10:25, then I know you sent me an email.
Why he's looking at it, I'm gonna object us to ask and answer. We've been through the fact that he sent him a copy of the motion, whether he specifically said rough draft or not, and then asked about the accuracy. He's explained his answer, and I've object to ask and answer. So
Understood, Mr. Levine. We're getting there.
He's
Overruled.
sweating, right, Blizzards?
And
Like a
then you
meatball.
responded when we were talking about that footnote that we were just talking about. I said, I took it out, but I can add it back. And you said, yes, add it back. Remember that?
I answered that, yes.
And then I said, anything else? Anything that.
Thank you for joining.
You recall that?
Bishop, welcome. Matt
Let me see
Allen,
that.
a South Texas prepper. Wake up, how you doing? This is a clown college show. I just changed the whole title. Hey, Sharon, I changed the title because I do not believe that we're going to get anywhere in any of this.
It says looks good, but as as I stated before, I was responding to you
Absolutely.
putting me back
self-defense.
into the motion for receiving $74,000 in a contract.
But that's not what this says. This says, you said, yes, add it back, and then I said, anything else, anything that isn't accurate, and you responded, looks good. So you weren't responding to put it back in.
Your Honor, I'm gonna object.
I
This is
know.
not his motion. He wasn't the affiant of the motion or verified the content.
Overruled, Mr. Body.
I was talking about his personal knowledge.
I've said
No personal knowledge.
twice.
Overruled, Mr. Body.
I've said twice that the looks accurate was, or I've said more than twice, was for the 74,000.
Do you remember telling me about Nathan and Fawny coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
And that was before she was elected as district attorney, correct?
I recall that that was when she was district attorney. Because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know, Miss Willis was there, Mr. Wade was there.
It was at our office. Actually, Miss Willis was there and there were other people there. Mr. Wade was not in that meeting. He was in the back. I wasn't even in that meeting.
Why did she hold it at your office then?
I have no idea.
You also remember telling me about them spending time together at her law office before she took her job.
I don't recall. Do you? I don't recall. Do you have something to?
Well, what I'm asking is, let's back up a sec. So Ms. Willis rented a law office from Evans firm, or Andrew Evans and another lawyer, I think Stacy Evans. You have knowledge of that, correct?
I'm gonna object to hearsay.
If,
Well,
How does he know the information? That would be the correct question.
okay. Ms. Mershon?
I don't really know even how to respond to that. Hearsay, I'm asking if he knew that she rented
Yeah,
offices.
he may have been there. He may
Right.
have seen a business card or something at some point. I think he can answer that.
I've never been to Miss Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was. So
Do you remember though, knowing that she rented an office
yes,
from the Evans?
yes,
You did know
that's,
that.
that is correct. Yes.
Okay. And do you remember telling me that Mr. Wade and Miss Willis would rendezvous at that office?
I'm gonna object to, again, hearsay as to how he knows that information. He said he has no personal knowledge.
He did not say he has no personal knowledge, Judge. He hasn't even answered it.
No, he said in general, he had no personal knowledge, so it's not been established the source of how he would know this because he said he's never been to her office.
All right. Ms. Mershon, if you, I know you're trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had knowledge of, I don't know if this is going to be relevant.
And Judge, I'm not even there yet, but again, that a speaking objection, and so now I would anticipate what our response is gonna be next. I didn't ask anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge. That's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if you knew.
Well, no, you're asking if you had knowledge and then you say of something specific. So,
Once I get an answer to that, if he has knowledge, then I will follow up with where that knowledge came
all
from.
right, well, let's try
Our
that.
judicial
So
system
my question
is
is, do you have
trash.
knowledge
If
of them
this-
meeting at that office?
It's a representation of it.
Okay, all right, overruled.
You have knowledge of them meeting at that office?
I have no personal knowledge if that's what you're asking.
I didn't ask that yet. I asked if you have any knowledge.
Objection, that would be
Nope.
hearsay.
Overruled.
Not if it came from
We
Mr.
don't
Wade,
know where it
Judge.
came from. So he said, how do you know, Mr. Bradley?
How do you know?
Any knowledge that I would have received would have come from my client at the time.
Okay, so you had knowledge of this place that Miss Willis worked. What did you know about them meeting at that office?
Objection, hearsay.
It's not hearsay,
Overruled.
Judge.
How he knows it, and then you ask the next question.
All right, he's already asked the next question.
Can you repeat the question?
Yes.
Oh my God.
How do you have knowledge? What knowledge did, well, you just told us. You told us Mr. Wade told you. So tell us what Mr. Wade told you about Miss Willis and Mr. Wade meeting at the Evans office.
Objection, Your Honor, privilege. This clearly covers the time after December 2018, it would be covered by the privilege.
Yeah, overruled.
After this, I'm gonna need some Woodford Reserve.
You recall the question, Mr. Bradley?
I do not.
You re-asked the question, Ms. Merchant.
What did you learn from Mr. Wade? I was clarified that's where you learned it from. About Mr. Wade and Miss Willis meeting at the Evans office together.
I don't object to asked and answered. He's testified that.
He hasn't answered. We haven't heard an answer.
He testified he had one conversation with Mr. Wade in the back of his law
Judge,
office.
Yeah, and his answer may change, so
Tip him
overruled.
off as to how to answer the question.
I can't recall what the conversation was. I do recall knowing that he would go down to the office or had been down to the office, but I can't tell you in what capacity or when or any of that. No,
Mr. Wade told you that they had sex at the office, is that correct?
I don't recall him stating that. No,
You don't recall
no.
it. So it's possible he did say that. You just don't remember one way or another?
I do not remember him saying that.
And do you recall that he had a garage door opener to either a house or a condo or something like that of Miss Willis's?
I've never seen a garage door opener. I've never been to Miss Willis's house.
Those were
I've
my
never
questions.
been to, and I'm trying to explain, I've never been. So no, I do not
A
have any
yes or
personal
no?
knowledge of him having a garage door opener. Yes, ma'am.
I didn't ask if you had personal knowledge, like as in you saw it. Do you have any knowledge at all from Mr. Wade or any source that he had a garage door opener to access one of Miss Willis's residence?
And I'll object to any source as to hearsay.
All right, depends on the source. Overruled.
No, I don't have any knowledge.
So when you told me that, did you just make it up?
Do you have something that shows that I told you that?
Yes, well, we're going to go through all the texts we can, but so was that made up though?
But I'm gonna object because I don't.
I don't recall him having,
Mr. Bradley, just
I'm
a
gonna
second.
object under 106 is the rule of completeness. I don't have that text message or any text messages that indicate that, Your Honor.
I was thinking the
And
same
I don't
thing,
have,
Vine
if
Dresser.
it was a text, we had that conversation. I actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure. But I mean, if I'm asked to qualify exactly where that's from, I would. give it.
Okay, so rule of completeness would be if you need to introduce other text to show the context. If you're saying you haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can
And I don't
decide your
have,
next step.
and that's what I was asking him. If that was something he just remembers making up. If he doesn't, then that's fine. But
She referenced text messages and started to go into her packet of papers.
Sure.
that have text
So you don't have a
messages.
text message to that.
I would need some time to look through, and I don't remember if I have a text to that or if it was during a conversation. It was one of those.
All right, well,
And I'm-
he has now said that he has no knowledge, so on to your next question.
Okay.
Why is Wade there?
Mr. Wade tell you about the trips that he and Miss Willis took?
no.
You have any knowledge of the trips that he and Miss Willis took?
Objection, hearsay.
Overruled.
I do now.
Okay, but you did not before this proceeding?
I did not know until you text that you found that in the deposition of his divorce. I mean, not deposition, but something from his divorce.
Okay, and when you responded, doesn't surprise me. They took many trips to Florida, Texas, California. Those are your words though, right?
I'm gonna object as to relevance. He said
Sure.
he did not know, and he actually learned from Ms. Merchant the information.
He said he learned about certain trips from Miss Merchant.
Okay, you can tie it down, but
Thank you.
we'll
He
see.
had no information on any trips that Ms.
Shut
Willis
up.
Wade took. That he learned it all from Ms. Merchant. That was his testimony.
Sure,
Judge, I'm
maybe
allowed
the
to.
conclusion we reach. I think she's going to ask more than one question, though. All right, Ms. Merchant.
And if Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Do you remember telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. You remember that?
I don't recall that, but if, I don't recall.
Okay. Judge, may I approach? It's
You may.
it's in one of the ones I gave you.
What I don't like about Ashley is that she never has her things tabbed. Everything that she's going to talk about should have a tab. She should always have a plan B. If he doesn't answer this, then change the tab to red. Okay, have a yellow tab to ask the question. And then if he says he didn't, always have that plan B in mind and pull back the red tab. Okay, then on this day, do you remember this? I've never seen people
Look at that.
This-
You know if it refreshes your memory.
unprepared.
So when that,
Do you remember it or not, Meatball?
yes,
Okay.
yes.
So it's true that you told me that they took many trips to Florida, correct?
Per that, yes, but one of the messages is cut off, and you asked about some other trips, and I said, no, I didn't, I think. And that was specific to, at the top of that, it says, no, I didn't.
Yes.
And so
Just shut up
that
now.
was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow.
Yes, you did.
And
You did not know about all the trips that were taken, and you qualified it. You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone, or whatever refreshes your memory, you said was after you left, after the firm was dissolved,
I'm
correct?
gonna object to relevance.
Overruled.
It was after the firm, the trips that you said, no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or whenever you found them. And I said, no, I didn't know about those trips. So
So you believe I mentioned that it was after you left?
I'm quite sure you have the text message, and I will refresh my memory.
Is it easier for you to refresh your memory with your own phone or with my printouts of screenshots?
Well, you have the printout, so I'll go.
Judge, the reason I'm asking is because I'm getting objections that I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be,
Don't you know
I don't
he
if he's
deleted
accepting
all of
or
that?
not, so you're gonna
would that be easier for you?
You can just provide the documents.
Okay. Let's see.
I mean, she wants him to take his balloons for fingers and thumb through an iPhone or whatever type of phone that he has. And it just tells me that she is not prepared. In tandem with knowing that they were going to do this major stalling, she should have been prepared and should have had everything tagged. Anything and everything that's pertinent needs to have a colored tab. Why is she thumbing through
Please, yeah, let me see.
at her place of employment? They really do, Betty,
Sorry, Judge, I'm just
because
trying
the
to
story
fly.
that I'm holding off on that's
All right.
already finished
Well,
is amazing.
I don't really see.
I would love to just
some
get
point
on
we're
with
reaching
that.
a cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he'd made some comments to you along the way that led you to believe he had more knowledge than today he's testifying that he had. And so if you've hit the high points of that, then I don't know what else we can cover that actually moves the needle.
Okay, I'll move on to the actual trips then. So you told me that they took many trips to Florida. That refreshed your memory. You told me that. Was that based on your knowledge from Mr. Wade?
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
The trips to Texas, and you're the one that typed Texas. Was that based on your knowledge from Mr. Wade?
Exactly.
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what would have been said by the client.
Obviously, and I'm not asking if you went on these trips. I'm asking if you have knowledge from Mr. Wade. You also typed California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the trip to California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of any trip would have come from my client at the time.
You told us last week that Mr. Wade used your credit card one time. Do you know when that was?
I do not.
Relevance. How we're here today.
Well, I think this would go to be impeachment of Mr. Wade's testimony if Mr. Wade testified that he had never used anyone else's credit card
I
before.
object to asked and answered because it was covered during the last hearing where he acknowledged that Mr. Wade used his credit card.
So,
Judge, I asked when.
just
I did.
when, okay,
I didn't ask, did he? I asked, when did he?
let's go there.
I do not have any dates of when Mr. Wade used my credit card. I testified that we used the card for business and that throughout the business, we would order paper or supplies or filing of depositions. I mean, the cost factor of cases is what I said, and that still applies today. Did he use my credit card? He did. But I
When?
can't tell you who he used that card, what the trip was for. I can't even tell you at this time where he went.
But he used it for a trip.
Yeah, it was for a trip, but I can't tell you where, when, why, or anything to that nature. Correct.
And he paid you back in cash.
I never testified that he paid me back in cash. I said that he would either pay me back. I said I couldn't remember.
Oh my
I do not
God.
recall. Sometimes he would write checks. Sometimes he would pay cash. And that still applies today, that I do not recall him paying me back cash, but I do recall him paying me
You
back.
guys, please hit the like button because I already see I'm going to
You thought
struggle
your
with.
partnership split up, correct?
It would have been before I left the firm, yes. He wouldn't have used my card after I left the firm.
Okay, so we can at least narrow down the dates to that.
Before I left the firm, yes.
Okay, great. And Mr. Wade gave you details about meeting Miss Willis in Hateville or East Point, as it was called.
That's incorrect.
He did not tell you about that.
He didn't give me details.
He did not tell you about meeting with Miss Willis at an East Point or Hateville apartment?
She's going to need to change her identity.
At this time, I don't recall. No, I don't recall.
Where did you get that information from then?
Thank you, China.
He's testified he doesn't recall if he even had that information.
I asked if he got it from Mr. Wade, and he says he doesn't recall. So then I asked where he got it from.
I do not recall where I got the information from.
And you and Mr. Wade were friends as well as business partners, correct?
We were friends in the sense of I've known him for years. Yes, we were friends.
And
Is that better, China?
you definitely did not want to come and be a witness in this case, correct?
That is correct.
And it was after, and we talked about this earlier, that Gabe Banks called you and then Nathan Wade called one of your friends. It was after that that you hired Mr. Chopra to assist you in this matter, correct?
Was it after that?
Is that better?
So I hired Mr. Chopra and I hired Mr. Graham. Now, Mr. Graham is here, and when I received the subpoena, Mr. Graham was here at the last hearing, but he also had to go out of town, but he was present. Mr. Graham, I called, and I had started getting calls from media, and I told him to respond to the media, I
China
think, and that
happened?
was somewhere around whenever you subpoenaed me. So it was, I can't tell you that it was that instance of those calls for Mr. Chopra. But I had engaged Mr. Chopra and Mr. Graham at that time.
Okay. I'm going to ask the question again because I didn't get an answer to it. After you got the phone call from Gabe Banks and from Nathan Wade to your
I
friend,
think it was before that, but however, I think it was before that is what I'm stating.
when you got the phone from Gabe Banks, you called me immediately. Well, actually, you texted me and then you called me.
I didn't call you immediately, but yes, we did speak.
And you texted me about it as well.
That is correct.
And then we spoke after Mr. Wade called your friend, and we talked about that as well, correct?
That is correct.
And at that point, you didn't mention anything to me about being represented by Mr. Chopra.
But I didn't mention anything about Mr. Chopra or, that is correct.
Yes, that was my question. Let's see. I'm gonna show you two more texts. They're in the ones.
All right, Ms. Merchant, we're gonna do
Those are the
5 more
last
minutes.
two questions. Thank you.
3:05, I'm cutting you off.
Thank you.
Knowing that he's possibly going to run the shot clock down. And she's going to need to change her identity like Marsha Clark after the OJ trial. Just get a whole new facelift. Get a whole new face. And she has to block him from looking at Wade, which has to be uncomfortable for the witness to sit there with Wade in the actual courtroom. I'm amazed. Somebody made a mention earlier that it was not a lot of people there. Well, he could have been one of those people who didn't show up.
Are these supposed to go together? Oh, these are two separate dates? Okay, all right.
So I know we talked about the other occasions where you said the texts were just about the footnote. But do you recall me asking you, do you think it started before she hired him? And you said absolutely. You recall that?
I see that in the text message, yes.
Okay. And do you also recall me asking you how they would react if they would attack me? And you said, no, they will deny it.
Your Honor, objection as to speculation as to how he thinks they will react.
I think that goes to the motivations of the witness overall.
And you told me that they will deny it.
That's written in there, yes.
I just want to, one last opportunity. You're an officer of the court, correct?
I am.
And you're under oath today.
I am.
Is there any of your testimony from today or the previous days that you want to correct?
That I want to correct?
Yes.
No, I told you everything that I've answered everything that you asked.
Thank you. Oh, Judge, just so the counsel and the state can have them, just for the record, I can admit those two that I
Well, they weren't ever tendered,
And
so it's just for,
I didn't know if they wanted
Right.
to use them, but I'll hold on to them.
if they need to be tendered at some point, then we can make them part of the record. All right, let me turn over to Mr. Sadow, if you're with us on Zoom.
Thank goodness.
Thank you, Honor. I do have a few questions. First thing I'd like to know is whether the court reporter has defense exhibits 26 and 27 from the last.
We have a different court reporter this time. We had to have someone else fill in on such short notice, but I can potentially send those to you if you need them.
Well, I think I have working copies, but I want to make sure that the witness has a copy to look at.
All right, we can try to work through that logistical challenge. This is, you said 26 and 27?
I believe that's correct. And 26, I think, is the same text messages that Ms. Merchant was just asking about. It was 2 pages. I stapled it together, and it is dated January the 5th of this year.
All right. I can print off a copy now, but why don't we start off with the questions that you have?
Okay, because
I can do it.
that's where I want. That's where I'm going to start, but I'll see what I can do to work through it.
It's not gonna work. Here, I'll lean on to.
He does remind me of Corinne Jean-Pierre. Just batty as a fruitcake, doesn't want to answer, has themselves in these bad situations. And that's the problem here, is this man
All right,
is
Mr. Seda,
tapped
why don't
in.
we start with your question, and we'll see if we actually need to get a copy of those exhibits in front of the witness.
All right. Mr. Bradley,
Yes, I'm here.
all of a sudden I've lost you on the screen. There we go. Well, you're on the Zoom. You're on YouTube, but you're not on the Zoom itself. But not that I can see.
I'm here. I can hear you.
No, I know. I think his visuals may be a little different. So hold tight, Mr. Seda. We could try to correct that. So that
Yeah, he was on. He was on when Miss Merchant was asking
we
questions.
we need to
Be
add,
able to see
I
you.
know, we need to add a spotlight to to the witness stand and a spotlight to Mr. Seda, and we don't need all the other boxes.
There we go. Thank you very much.
Well, then hold tight, Mr. Seda. We need to add you as well.
This guy is done.
All right, now we're ready.
Thank you, sir. Mr. Bradley, you have referred to Mr. Wade as your client, correct?
Correct.
You understand that the court has ruled that communications that you had with Mr. Wade are not privileged, correct?
No, I'm aware that the court ruled that one specific dealing with the time frame of one specific conversation wasn't privileged.
Then I'm going to ask Your Honor, if it's that the limitation or
Excuse me. To clarify.
email,
Sure. Mr.
Sorry.
Sada, you asked whether all communications with Mr. Wade, I think, were covered. That was not the extent of the ruling. The only ones that I deemed were not covered and that I'd asked about in the in-camera hearing, because those are the ones that were relevant, were any communications Mr. Wade made regarding the existence or non-existence of a romantic relationship with Ms. Willis.
fine, thank you, Your Honor. I understand. So going back to this line of inquiry, when you say you don't have personal knowledge, what I want to ask you to start with is very simple. Did you have communications with Mr. Wade about the relationship between Mr. Wade and Ms. Willis? It's a simple yes and no.
Yes.
And is it your testimony that during the time you were representing him, which I understood started sometime in 2018, is that correct?
That's the time frame that I remember, yes.
Is it your testimony under oath that with regards to conversations with Mr. Wade about his relationship with Ms. Willis, that you only had one such conversation during the time you represented Mr. Wade?
One conversation of what? I apologize. It
The only
broke
thing
up.
we're about, the only thing I'm asking about is that area that the court said is not privileged, which is the relationship between Mr. Wade and Ms. Willis. You've testified that during the time you represented Mr. Wade from 2018 on, that you only had one conversation with him in reference to the relationship between Miss Willis and Mr. Wade. Is that correct?
Yeah, I think that's fairly accurate. Yes.
Okay, so out of the entire time, I'm talking about could be 2018, 2019, 2020, 2021. When did you stop representing Mr. Wade?
It was a few months after I left the firm.
All right, give me the approximate time.
I left maybe June, July of 2022, maybe.
So that would suggest that for, assuming it's 2018, 2019, 2020, 2021, and half of 2022, which is in the vicinity of 4 to 4.5 years, you're testifying under oath you had one conversation about a relationship between Mr. Wade and Miss Willis. Is that correct?
I don't recall having any other conversation with Mr. Wade about him and Miss Willis.
Is it your testimony then that you don't remember any other conversation, or there wasn't any other conversation besides the one?
I'm gonna object as to asked and answered.
I think he's drilling down. I think that's a fair question overall.
I don't recall. I would say it was the one, but I don't recall.
You testified that you did have communications with Mr. Wade about him visiting with Miss Willis at a condo or apartment, correct?
I don't think I testified that I had a conversation. I testified that any knowledge that I would have known anything about any condo would have come from that, but I don't recall a conversation about that. I do not recall a conversation about that.
Okay. Do you recall any other thing at this point in time under oath that would indicate when the relationship started between Mr. Wade and Miss Willis?
I do not know when the relationship started between Mr. Wade and Miss Willis. I cannot
Okay,
recall
so
that. I can't. Oh, I'm sorry. Go ahead.
I'm going to drill down on that now, okay?
Yes, sir.
Mr. Wade was hired as the special prosecutor on November 1st of 2021. You're aware of that, correct?
I have my contracts to show when I started.
Oh, wow.
No one showed me the contract of when he started, but but if he has a contract for November 1st of 2021, then that's correct.
I'm going to suggest to you that the record will reflect that the contract between Miss Willis and Mr. Wade was November 1st of 2021, correct? I want you just to accept that, okay? Is it your testimony that you don't know under oath whether or not there was a relationship between Mr. Wade and Miss Willis before the contract?
I do not recall any dates of when the relationship started. So whether you are pinpointing a date of when his contract started or not, I'm telling you, I did not recall any specific date that he flat out said anything about a relationship with Miss Willis.
Okay. Now I want to go, based on what you've just said, let's go to what was Defense Exhibit 26. Okay, in Defense Exhibit 26, which I showed you last time, was 2 pages of text messages between you and Miss Merchant, correct?
Correct.
All right. Now, the first page starts off by saying, Miss Merchant, like just date, don't hire him. Do you think it started before she hired him? You see that?
Yes, I see it. Yes.
And your response to that was absolutely, correct?
I'm gonna object, asked and answered in cumulative.
All right. So, Mr. Sato, I do think we went through a lot of these texts
No, let
We
him
didn't go
answer
through this
that.
whole one.
Just a second, Mr. Sato. All right. I'm sorry, Mr. Sato. Well, you said we didn't go through this particular one?
No, we stopped right there. I
No,
want to go,
I answered, because this
So
is the
what-
exact
there's not-
language that she just stated a few minutes ago. You could read it back
Okay, Mr.
in the
Sato.
record.
Are you saying both of these two exhibits weren't already covered by Ms. Merchant?
it was not gone, this particular language was not gone into. I'm doing it based on the exhibit itself. Well, let's do it this way. I now move into evidence defense exhibit number 26.
All right, and I'd have to search through my notes, but does anyone recall that one actually been tendered in a minute already?
It was.
No, it was only presented to your honor for you to take back into camera ex parte to speak with Mr. Bradley and his counsel.
Okay, Ms. Merchant is indicating that it was admitted.
I thought Mr. Sadow admitted it, but I'm organizing, putting them back in order. So I think it might be easier if I just admit the copies. of the
All
I
right.
think
documents
she's
I'm referring to.
done
All right, so
enough.
Defense Exhibit 26 and 27 are being tendered.
Well, actually, only 26 at this
Excuse
time,
me. Okay, Defense Exhibit 6, any objection from the state?
but 26.
26.
I'm going to object as it relates to foundation and authentication. It was used during the last hearing for the purposes of refreshing his recollection. And it's my recollection is that it didn't refresh his recollection, but I renew my objection as to asked and answered and cumulative.
Okay. As to foundation on authentication, I think Mr. Bradley has recognized them as texts that he sent and received. So I think I'd overrule on that basis any other objections to their admissibility from any other defense counsel, and seeing none. Defense Exhibit 26 is now admitted. Mr. Sadow.
Thank you. All right, let's continue. Now I'm publishing it. After you said the word absolutely, on your own, you said it started when she left the DA's office and was judge in South Fulton.
No, no, I'm gonna
They met at,
object,
Yeah.
asked and answered.
All right, understood, Mr. Body. I'm going to let Mr. Sadow have a few minutes on this, and we'll go from there. But
Judge, well, I'm sorry. I did answer this. I answered it for Ms.
understood.
Merchant. I stated that I was speculating. The judge, someone objected to the speculation, but this was the exact same language.
All right, well, thank you
when
for
I
that
said that
recap,
I
Mr. Bradley. Mr. Sadow's
speculate.
asking the question in a slightly different manner, and I'm going to give him a little bit of leeway to do that. So, Mr. Sadow.
all right, I hesitate to have to start back where I was, but after the word absolutely, you on your own said it started when she left the DA's office and was judge in South Fulton. They met at the municipal court CLE conference. That's what you said, correct?
That is correct.
It's your testimony, at least so far, that when you on your own gave those two statements in the text, that you were merely speculating and did not have that knowledge from Mr. Wade. Is that your testimony under oath?
Yes, that's what I testified to. Yes, sir.
So you on your own came up with the whole notion that it started when she left the DA's office and was judge in South Fulton. That's, according to you, that's speculation on your part,
Objection,
correct?
asked and
Overruled.
answered.
Answer the question, Mr. Bradley.
Yes, that's speculation on my part. Yes.
Right. It had nothing to do with what Mr. Wade had told you, correct?
I answered your question. I was speculating to the answer.
Answer
That
the
is correct.
question, Meatball.
So maybe you can tell the court in your own words, why in the heck would you speculate in this text message and say that it started when she left the DA's office and was a judge in South Fulton? Why would you speculate and say that in a text?
I knew they had met at the municipal court conference.
How do you know that? I'll stop you right there. How did you know that?
I answered that at the last.
I'm
I knew
asking
that.
you now.
I knew that
Sir,
because
I'm
when
asking you I'm asking you questions, and you are in a situation where you get to give answers.
Mhm.
I'm asking you, how did you know that?
How did I know when they
Somebody
met?
told- Somebody told you that, right?
When they met?
Yeah.
Yes, correct.
Who told you?
Mr. Wade told me when they met.
So you had more than one conversation about the relationship between Mr. Wade and Ms. Willis because he told you where he met her.
That's
Correct?
incorrect. Incorrect.
It's incorrect.
It's incorrect.
Let's go back to the exhibit. Why would you speculate that that's when they started the relationship? What would cause you to put that down as speculation?
I don't recall, but why I thought that it started at that time. But I do recall that he only met her, and I testified to that he met her at that conference, which was in 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her, correct?
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade was because she was trying to show when the relationship began, correct?
No, that's not 100%
It's not. Look at the
correct.
beginning of the text message.
Yes, but what
Text message-
messages were before this message, before she sent that?
I can't answer that question because I don't have them. All I have is what's in front of you.
Yes.
And it says that she says, do you think it started before she hired me? So you knew as the counsel for a defendant in this case, that Ms. Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Ms. Willis, correct?
I mean, based on this, yes, I see what
And
was
in-
asked.
And in response to that, you answered directly on your own what you now claim to be speculation, right?
That's correct.
So I ask you one more time before I move to the next part of this. Why would you speculate when she was asking you a direct question about when the relationship started?
I have no answer for that.
Except for the fact that you do in fact know when it started and you don't want to testify to that in court. That's the best explanation.
This is completely
Overruled.
argumentative.
That's the true explanation because you don't want to admit it in court, correct?
No, I have no direct knowledge of when the relationship started.
I'm not going to go back through that again. Well, if you didn't know and you were asked specifically as this exhibit shows,
Mhm.
maybe you can explain why you wouldn't say, I don't know.
Is that a question? You're asking me a
yeah,
question to answer?
definite question.
State that again. I apologize.
If you're being asked, as we've just gone through with this text message from Ms. Merchant,
Yes.
as the attorney for a co-defendant,
Yes.
and she's asking you about the relationship, and she's clearly asking you about the timing, why wouldn't you just have said in response, I don't know when it started?
I don't know why I didn't say I don't know.
Maybe, again, it's because you know what the truth is, and that's why you answered exactly the way you did in Defense Exhibit 26, correct?
No, I can't sit here and tell you that what you just stated was correct.
Right. What you want the court to believe, and you want the rest of us to believe, is that for some unknown reason, upon being asked a direct question about when the relationship started, you decided on your own to simply speculate and put it down in a text message as opposed to putting down what you actually knew. That's what you want the court to believe, correct?
That was a lot. So can you break that down? I apologize. You're asking me, do I want the court to just
To believe that instead of saying nothing, you decided on your own to speculate.
Yes, I speculated. Yes, I've stated that I speculated. Yes, sir.
Right. That's what you want the court to believe, correct?
That's correct.
Okay, now, then when you go to the next page of that, okay, you see it starts, the best that I can see, it starts in South Fulton. Is that what you have in front of you? Second page.
The second page that I have says, that's what I figured.
Okay, that may be cut off from the one that I have. I'm looking at my opening line says in South Fulton. Is that on your second page?
No, so if you're going in order of the pages, no, neither page starts with South Fulton.
No, don't get caught up in whether it starts that way. Does the second page have a line in there that says in South Fulton?
Oh, yes, I apologize. So, yes.
That's fine.
Yes,
Just want to make sure that we're on the same page.
yes.
Okay. You say after in South Fulton, they met at the municipal court CLE conference, right?
Yes.
You see that?
Yes, that's correct.
And then Miss Merchant says, that's what I figured when he was married. Is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. You see, that's what she said, right?
No, I mean, so it says they
Wait.
met at municipal court CLE. The only other thing here says that's what I figured when he was married. There's no response for me on that day. And then there's another response. I guess a question that says, is this accurate?
Okay, that's what I just went over with you.
Okay, so I don't have anything in that. Is this accurate at all? I can show the court.
No.
It just says, is this accurate with the question mark? I don't have anything following that.
You don't have, after that, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship
Okay,
at that time.
I apologize. It goes to the next page. I apologize.
Yeah,
No
meatball.
problem. Just
Yes.
want to make sure
So
that.
I see that now. Yes.
All right, so that's what I just read is exactly what Ms. Merchant said to you in the text, right?
Yes, that was in the text. Is it accurate upon further information? Yes, that's there.
And
Yes.
again, since you have told us that you were speculating when you gave the answer that we went over with previously, on this one, you don't say, I don't know. You simply correct her by saying no, municipal court, right?
Yes, so she asked, was it accurate? And I said it wasn't accurate. No, it wasn't accurate. It was municipal court.
Right, and when you said it wasn't accurate, it was municipal court, you didn't say, no, that's not accurate. They didn't start a romantic relationship at that time, correct?
No, but I was referring to the municipal court. No, it wasn't accurate as it applied to I was answering the no municipal court, meaning when she said, is that accurate? It was to the municipal court and not magistrate court.
Okay, but you didn't say that the rest of what she asked you was accurate. You didn't say, no, that's inaccurate. That's not true. That's not accurate. You simply said the only thing that wasn't accurate was municipal court should be there instead of magistrate, right?
So I was answering the question
Wow.
of, it was a compound question. And
you
I was answering the question of, she wrote magistrate court and I said, no, municipal court.
Right, but it's not compound. It's one statement.
right,
Upon
Mr. Sadow.
information, I'm sorry.
No, that's okay. I know the feedback and the delay is complicates things, but I think you've adequately made your point here. I don't think we need to belabor it much longer. Let's move on to the next issue.
Okay, thank you, Your Honor. Mr. Bradley, prior to coming into court today, did you and your lawyer meet with anyone from the district attorney's office?
No. I mean,
Did your-
no, not that I know, I'm aware of, no. I
Have
did
you
not
had
meet to
any-
anyone.
Sorry.
I did not
cut
meet
you
with
off.
anyone outside of my attorneys.
Did you have any conversation?
I did not.
Meeting, conversation.
I did not.
So you have not spoken, if I understand you correctly, prior to coming into court today, you've not spoken with the prosecutors,
No.
right?
I've not spoken to the prosecutors. I've not spoken to defense.
Have you spoken to Mr. Wade?
No.
So as far as just getting into the courtroom today, there's been no contact or conversation in it with any of the parties we just went over, right?
There has not been any contact with defense or the state at all.
I think I have basically just one or two more questions. Why would you see the need to speculate when you were texting with Miss Merchant?
I think we did cover that one, Mr. Sadow. I think that exact question was already put to him. What would be the next one?
I'm trying to look. Let's go to 27. Defense Exhibit 27. Do you have that now, sir?
I do, sir.
All right. Would you look at it and tell me whether or not the Defense Exhibit 27 appears to be accurate? Because I want to seek to introduce it into evidence. It consists of an email to you from Miss Merchant and a text response from you, correct?
But the text response was not in response. So yes, it does consist of the email and a text response. I'm not saying that the text response applies to the entire email that was sent.
All I've asked you right now is,
Yes,
is the email and the text, are those accurate in the interaction that makes up Defense Exhibit 27?
as it applies to the stapling of the email and the stapling of a text message chain, yes, that is Defendant's Exhibit 27. This is, it's accurate.
Okay, I would move Defense Exhibit 27 in. I believe it was treated the same way as 26 last time. Your
Same
Honor.
objections, Mr. Abadi?
Yes, Judge.
All right, overruled. Any other objections from defense counsel? Seeing none, defense exhibit 27 is admitted. Anything else?
Your Honor, I don't know. Yeah, I don't know whether you'll find this objectionable or not. I'll ask it, obviously.
All right.
Mr. Bradley, you realize that if you were to testify under oath, that you knew from Mr. Wade that the relationship between him and Miss Willis existed before the contract in November 1st of 2021, that if you testified that you knew that from Mr. Wade, that would show that both Miss Willis and Mr. Wade had lied under oath. You know that, don't you?
I'm gonna object.
I think that's going to call for an opinion on the credibility of another testifying witness. So I don't think that would be an appropriate question.
Then that's all I have, Your Honor.
Thank you, Mr. Sadow. Mr. Stockton,
Just briefly, Judge.
we'll see.
Mr. Bradley, do I understand from your prior testimony that Ms. Merchant sent you a motion to review prior to her filing it?
Objection. I'll some cumulative answers.
Right. I'm going to give him just a little bit. All right, Mr. Stockton, maybe this is going somewhere else.
Did Mrs. Merchant send you a motion prior to January 8th of 2024 for you to review?
That is correct.
And did you in fact review that motion?
That is correct.
And did you indicate to Ms. Merchant that the contents of that motion seemed okay to you?
Well, so you're referring to Exhibit 27,
Yes or
which, as
no?
I stated a few minutes ago, one is an email, one is a text chain. So in the text chain, when I never responded to the email, I never responded looks good or anything to the email that was sent to me. However, in the text chain, what you all are trying to merge together is the fact that I was asked about the contract, and that contract was $74,000, and me being added back to that. So when I said, and I think before that in that text, it referred to me being added back, and at that time I said yes, looks good.
And you're aware and you recall that when Ms. Merchant presented you with that motion, she asked you not to disclose it to anyone until she filed it. Is that correct?
We are covering, I think, the last 5 or 6 questions. We've covered ground. Let's get to that ultimate point.
I'm trying to get there, Judge, I
All right.
promise you.
Okay.
Repeat the question, I'm sorry.
She asked you not to disclose that motion to anybody until she filed it, correct?
I think so. I think that was in the text message, yes.
And you knew, in fact, it was her intention to file that motion, correct?
The actual motion that she, that was sent,
Yes.
I knew that she was going to file a motion, yes. I do not think that that was the final draft, or it could have been that she was working on it, but yes, I knew that she was going to file some motion, yes.
And you knew that she presented that motion to you for your review so that she could make sure it was accurate, correct?
Your Honor, I'm going to object. All this is asked and answered in cumulative.
All right. Noted. I think Mr. Stockton's getting to the next point. So why don't we just ask that one?
Is that correct?
Did you?
Why don't we
I thought
why don't we
you.
combine that with the next question, so we're not having to lay bit by bit every single time.
Mr. Bradley,
there's a
you
question.
knew that Mrs. Merchant was relying on your review to ensure the accuracy of that motion prior to filing it, correct?
Speculation as to what he knew that Miss Merchant knew.
No,
Gonna do.
I'd overrule that. Mr. Bradley?
No, so once again, I was excluded from the footnote of that motion, and my review of it, and I said, hey, you need to add me back to the footnote because I did have a contract and I did receive $74,000.
If I may help you out, let's talk just about that part of the motion that deals with the relationship between the District Attorney Willis
Mhm.
and Mr. Wade.
Mhm.
When you reviewed that, you knew that that Ms.
No.
Merchant,
No, I did not know that she was relying on me for any relying on me for any accuracy other than what was put in there
if there
about the
was,
74,000.
Mr. Bradley, if there was something patently false in that motion, you would have told Ms. Merchant, wouldn't you?
I can't say that I would or wouldn't have. I don't know what I would have told Ms. Merchant.
If there was something patently speculative, you would have told Ms. Merchant, wouldn't you?
I don't know what I would have told Ms. Merchant. She asked me, was it accurate? We were discussing the 74,000 that was left out.
Again, if I may direct you just to that portion dealing with the relationship between Mrs. Willis and Mr. Wade. You didn't tell her that there was anything patently false in that because you didn't see anything patently false in that motion as it relates to the relationship.
Repeat your question. I'm so sorry.
You did not inform Mrs. Merchant that there was anything patently false in that motion that you were presented with as it concerns the relationship because you did not see anything that was patently false, correct?
Objection asked and answered cumulative.
All right, next question, Mr. Stockton. Sustained.
And you didn't see anything that was speculative in there either, did you?
Asked and answered cumulative.
I know, sustained, Mr. Stockton.
I just want to ask you one more question. I'm coming at from the other way that Mr. Sadow did. Did anybody from the district attorney's office or any witnesses in this case contact you about Ms. Merchant's motion from January the 8th of 2004 until today?
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the only personal call that I had was with Gabe Banks. I never spoke to anyone else, and to my knowledge, he's not a part of this, so.
That's all I got, Judge.
Thank you, Mr. Stockton. Mr. Durham, if you're still with us.
No question, Your Honor.
Thank you, sir. Mr. McDougal.
Good afternoon, Mr. Bradley. You have certain information about the relationship between Mr. Wade and Ms. Willis that is not privileged, correct?
Well, that was my determination, so I think he disagrees with it. So what we're going to say his opinion's a little irrelevant on that point.
Do you understand that the court has ruled that certain information that you have about the relationship between Ms. Willis and Mr. Wade is not privileged?
The court's ruling, as I understood it, and as my lawyers and I understood it, of the privilege not existing was based off of a conversation that was had in my office, in the back of my office, which was confidential, with Mr. Wade and I. That's what was asked of me on yesterday, and that's what the ruling, to my knowledge, unless I'm being corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Can you ask that again? I'm sorry, I didn't understand it.
Referring to what you understand to be the information that is not privileged, have you testified to the sum total of that information?
I think I have, yes. I think I've testified to that, yes.
All right, sir. That's my questions.
Thank you, Mr. McDougal. Mr. Rice.
Mr. Bradley, at least as of February 15th, when you first testified, you said you still considered yourself a.
I think I said that, yes. I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
And you recall communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
I'm going to object as to asked and answered and cumulative by all three of the previous.
Sure. We don't have to lay that foundation. Why don't we combine it with the next question where you've got a new point to make?
Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
That was good. Well played.
Did I lie to Miss?
That's a
I mean-
simple question, Mr. Bradley. You're a lawyer. Did you lie to Miss Merchant when you told her facts about Mr. Wade and Miss Willis's relationship?
Not that I recall. I don't
Wow.
recall. I mentioned earlier that I speculated on some things. I've testified to what I did know. So I can't recall whether or not no.
Mr. Bradley, speculation is kind of a weaselly lawyer word. Let's speak truth here.
Then
You're
it's
under oath.
Argumentative at this point, Your Honor. I have relevant questions.
All
Mr.
right, let's
Bradley,
find a question, Mr. Rice.
Mr. Bradley, when you were communicating different details of the relationship between Miss Willis and Mr. Wade to Mrs. Merchant, did you lie to her about any of those details?
Objection asked and answered twice.
I don't think he's answered it yet.
I don't recall ever whether any of it was a lie or not
Well,
this time. So
at the time you were communicating with Miss Merchant, you were still friends with Mr. Wade, correct?
Come on, meatball.
yes,
And at the time you were communicating with Miss Merchant, you knew that she was talking to you in her role and capacity as an attorney in this case, correct?
correct.
And you knew that she was going to use that information to somehow benefit and file a motion, benefit her client, correct?
Object, this is
I did not know that.
Okay,
So I did not. Well, I'm sorry.
So as an attorney yourself, you are testifying here under oath that you had no idea what Miss Merchant was going to do with all the details that you were giving her about Wade and Willis's relationship.
So at the time, no, I did not. I knew that Miss Merchant was gathering information. That is correct.
Okay. And did you lie to her when you told her that the relationship began
All right.
before
I
2021?
don't think we need to drill into specifics. He's covered it at a high level. I don't think we're going to get much out of this.
Mr. Bradley, isn't it true the only thing that has really changed? Well, you were speaking to Miss Merchant, whether by text or by telephone. You never said to her that I don't remember or that I'm speculating, correct?
I don't recall.
Well, you've looked through a whole lot of text messages. Do you remember ever seeing any communication from you that said, I don't remember?
You're just toast.
Yeah, through the messages that I don't have all the messages in front of me, but no, I don't recall if I ever said I don't remember.
Do you recall seeing any text messages where you replied to her or gave her details where you said, I am speculating about this detail?
No, I never used the word speculating. No.
And the only thing that's changed between then and now is that phone call from Nathan Wade's friend, Gabe Banks, correct?
No, well, Gabe was my friend, and I actually stated that the first day that I was here was that I've known Gabe for a few years, and that we were not were, but we are fraternity brothers, and so I never said that that anything changed behind Gabe Banks.
So you never told Miss Merchant that you were worried that they were threatening you?
Objection asked and answered when he was asked this on February 16th and today.
Mr. Rice, we've covered this.
And just to be clear, you didn't attend college with Mr. Banks, did you?
I did not attend college with Mr. Banks.
When you referred to him as your fraternity brother, y'all just both happened to have pledged the same fraternity, different colleges, different chapters.
Well, that's what we consider fraternity brothers, yes, sir.
And as a normal course of your relationships with your friends, do you pass on lies about your friends?
Have I passed on a lie about a friend? Is that what you're asking?
Is that something you normally do, Mr. Bradley? Do you tell lies about your friends?
Have I told lies about friends? I could have, I don't know.
Do you tell lies about your friends about a case of national importance?
Objection as to,
All right, overruled.
I could have, I don't know.
Mr. Bradley, I notice you're not looking at me.
I'm looking at you on the screen only because I was accused of, and I did the same thing to Mr. Sadow when he was on the
What's the
screen.
next question, Mr. Rice?
No further questions, Judge. I think it's clear.
Thank you, sir. Mr.
He
Gillen.
said, I think it's clear that Meatball is a liar.
Good afternoon, Mr. Radley. A few questions. A lot of folks have taken up the questions that I wanted to ask, but I've got a few left here.
We'll see.
We'll see. You said Mr. Radley, you said you didn't know what Ms. Merchant was going to be doing with the motion that she sent you. You remember that testimony a few minutes ago?
I think I said I didn't know that. I knew that she was gathering information, yes.
Well, let's look at the title of the motion that she sent you. Do you remember reading?
That was sent on the 6th.
Excuse me, do you remember reading the defendant Michael Roman's motion to dismiss grand jury indictment as fatally defective and motion to disqualify the district attorney, her office, and the special prosecutor from further prosecuting this matter? Do you remember seeing that in the draft that you read and reviewed?
Yes.
So when you tell this court that you didn't know what she was up or what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she sent for you to read? Didn't she? Yes or no?
I read the title of what the motion was.
There wasn't anything in the title that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment, to motion to disqualify the district attorney and her office and the special prosecutor from further prosecuting the matter, right?
I'm going to object to speculation.
You knew that, didn't you?
Overruled.
Yes or no?
When she sent that motion, yes.
Okay. And you knew that the special prosecutor that to whom she was referring in that motion was Mr. Wade, correct? You knew that
Yes.
because you read the motion. You said you reviewed it, correct?
Yes.
And we're not going to go over all of the, number one, because we don't have time, and number two, the court wouldn't let me. But but there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion that you said you reviewed, on page 6 of that motion, well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right.
You're saying.
Yeah, Mr. Gillen, I can appreciate what you're doing. I think that's something you can do at argument. He's said as a whole that he got the motion and he's had his response as to his opinion of how he handled it. I don't see that, again, this really being necessary to go through it line by line of what.
Well, a little indulgence, Your Honor. I'm not going to go, this isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would ask the court's indulgence in that respect.
Again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it, and he never objected to anything in there or raised it. So
That's a problem, and always ending up last.
it very much is. And next time asked, I'll reshuffle the order.
Well, we did earlier with Mr. Wade, and then
I hear you.
that was kind enough, and then the court said we had to go.
Don't need to draw straws next time.
There we go. I'll go with that.
All right.
Thank
Anything
you, Your
else?
Honor. That's all I
Okay.
have.
Okay. We had Mr. Kucherov potentially still on Zoom.
Yes, Your Honor, and I have just a few questions.
All right. Could we add a spotlight to Mr. Kucherov? I'll let you know when we're able to proceed.
Judge, before he starts, can I take a 5-minute restroom? It's been
Absolutely.
2 hours.
Yeah, we've been going 2 hours. So let's come back at 4 o'clock. I'll also note for the record that we received a notification from Mr. Cromwell on behalf of Ms. Latham, and he said he was waiving her presence. And I don't know if he later decided to join us by Zoom, but I don't think he was electing to log in. So after Mr. Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
I don't imagine my question would be very long.
Okay, well, let's get back in at 4 o'clock. Mr. Bradley, you can just step out of the jury room.
Okay, so they're going to take a 7-minute recess. And while they do that, I have some information that I wanted to share with everybody. They may already be back. So let me fast forward it. No, they're not, because what I had done was I had stopped it a couple of times, if you guys may remember. And so I was trying to see if perhaps they had come back. Let me come over here and talk to you guys. But there's some information that I have that I found out was very troubling, comical, but troubling at best. And that was dealing with the coverage that I've been taking care of for the young lady that is definitely skating now, based on the information that I've been able to see. To me, just as a layman, it looks like the Dalton city mayor is running on. She's like following behind the RICO. And the reason why I say that is because this gal has now employed the majority of her family, as well as several friends. And I was peeping around last evening, pretty late, and found a great deal of information, things that were coming out of her own mouth. It's amazing the stuff that you see when you start plundering around different of these social media apps. A lot of these social media apps have been the lifeblood and the death of people as well, because sometimes you can, excuse me, welcome, Sandy. Sometimes you can go on there and you can say things thinking that, there's not a problem in the world. And then other times you can go on there and you do nothing but create havoc for yourself. And I believe that's what she's done. So there is a clip, several clips that I put together last night, early this morning, for everybody to see. And when I tell you this gal has more problems than not, I know that I'd love to separate it from here and share it with you. But what I think I'm going to do is just go into it and show it. And then once this is uploaded, after they come from break, obviously we'll have to come back to this. But I'm thinking that what I'd like to do is go on ahead and share some of it with you. And then I'll exegete that out, or I'll clip it out, cut it out later, and then make it its own video. But just for the sake of, having nothing going on, I can do that. Or I could also look at some of the newest news briefs that have come up since we've all been here, which is what is important for us to do. And here's why I say that, because they're sticking this stuff on, and we are totally disregarding all the other stuff that's going on. There's one big story. I don't think I want to put that here, but let me just read it to you, and you guys let me know, should I make this into a second video as well? I believe that I should. So let me give it to you guys. Hold on just a moment. There it is. All right. Here it is. There's a couple of stories now. Now, it's dealing with the U.S. federal law enforcement documents. Some of them have been revealed. And in the revelation of these documents, the article states, the communist Chinese government has been flooding the United States with illicit gun parts as a part of its disintegration warfare strategy. It is employing against American citizens, armed, or it's aimed at tearing the country down from the inside out, which is what a lot of us have already been saying. Now, this comes from a book that's been written by Peter Schweitzer. He's the Breitbart News's contributor, and this is a book that he's written. But in this book, he's referencing all of these documents, the law enforcement documents. And it's quite troubling, because in the book, it's called Why the Powerful Turn a Blind Eye While China Kills Americans. Schweitzer reveals how Chinese companies, which are heavily regulated by Chinese government, are flooding the United States with auto sear switches. Now, They're small metal devices, is what they are. They're also known as Glock switches that can convert handguns into machine guns. They are illegal for most gun owners in the United States, but they're being shipped in boxes by the thousands from China. This is what Schweizer reveals. He goes on to say that, as with fentanyl, the Chinese government is sending the auto sear switchers to sow chaos and death in the United States as a part of a disintegration warfare strategy. This strategy focuses on the Chinese leader's words going after the United States, quote, soft underbelly, in the term of politics, economics, and the spirit of psychology of its people. Now, it's based on the accident, or excuse me, I'm wearing the old glasses today, but it's based on the ancient Chinese teaching of Sun Tzu's teaching on how to win a war without fighting. The strategy is aimed at undermining a rival country's national will, values, and cohesion. In this book, he uses the leaked US federal law enforcement documents to reveal how China is trying to arm felons and criminal gangs across the United States with these switches. Now, the devices are about the size of a penny, and they started arriving in the United States in large quantities back in 2018. Now, I remember Bettina sharing this with me, these little things, and she showed them to me in an article. She had sent me the article, and I looked at them. I was like, wow, what are those? And then she said, there are boxes and boxes of them, and they're coming across the border. So what she showed in the article that she shared with me. But I don't know where the article came from. That's the only thing. Nonetheless, it says they are illegal in the United States except for use by law enforcement personnel and a select group of others who must obtain a federal license requiring an extensive background check. Thus, criminals in the United States purchase them illegally from China via Chinese websites that are English and target Americans. Accordingly, between 2019 and 21, there was a rise of 4,200% in incidents involving machine gun fire in 130 American cities. He reveals that although some of the illegal auto switches are made on 3D printers in the United States, the vast majority of them on the streets are from China and are of much higher quality than those that are made of the 3D printer type. A U.S. law enforcement, I'm looking, making sure that they're not back. As U.S. law enforcement has become better at identifying these switches coming from China, Chinese producers have switched tactics and have increasingly are shipping them to Mexico and smuggling them across the border. Now, do you guys remember that we were just looking at all of the high influx of the Chinese people that are coming over the border? So this is telling us something that we could connect the dots if we choose to. We could, someone would be able to assume that, yeah, some of these people are bringing them over with them. Maybe not. So it says that they're smuggling them across the border into the United States, where they eventually end up in the hands of gangs, felons, and drug dealers. And drug cartels in Mexico are also starting to manufacture these devices themselves, using machines provided by Chinese companies. This is what the author of the book reveals. This is what he writes, quote, "This is a strikingly similar replay of the Chinese government strategy with fentanyl. When U.S. authorities successfully began blocking shipments sent from China via mail or parcels, Chinese sellers switched to the land bridge in Mexico to continue supplying these devices to criminals in the United States. This delivery saturation around the United States warned the Department of Homeland Security in an internal memo obtained by the author with a map showing that distribution is concentrated in major cities, including Los Angeles, San Francisco, Chicago, Detroit, Miami, Washington, New York, and Philadelphia." Okay, they're back. Let's go back. Sorry, guys.
The day that, I don't have the date, but it was the date of whenever the phone call happened.
You know, his wife, Kyra Banks, works for the DA's office, right?
Yes, correct.
When was the last time you spoke to Mr. Wade?
I'm spoken to Mr. Wade personally in a year, 2 years actually, when I left the firm.
Miss Willis?
I never, my interaction with Miss Willis was never where I would pick up the phone and talk to her, or that she would, or anything like that.
So you didn't hang out with Miss Willis? You didn't have a personal relationship with her?
No, I never had a personal relationship. I mentioned before that I went to a dinner that was after she was elected. That was at a steakhouse, but it was some 75 to 100 people there.
So you knew of her, you just didn't have a business relationship or a personal relationship with her, or at least a close one?
I knew of her from she was in the DA's office and I had criminal cases, but I did not personally know her, no.
And not having known her, not really hanging out with her, you've got a contract from her office.
I'm gonna just object as to cumulative asked and answered throughout the.
All right, Mr. Sheriff, I think we covered this ground on the 16th about the contracts. Do you have are you going somewhere else with this?
I am, Judge. If you give me a little latitude, I'll
All right.
tie it right now.
Okay, you may proceed.
You got a contract from the office, not knowing or having a good relationship or a good working business relationship with Miss Willis.
That's correct.
That's because Nathan Wade steered that contract to you.
I don't know how it came about, but it was presented to me at the office about the contract, correct?
Who presented it to you? Mr. Wade?
Yes.
And he owed you money, you said at one point.
Say that again?
Owed you money at one point?
I don't recall saying that he owes me money.
Did he owe you money at one point?
Not that I recall saying that Mr. Wade owes me or owed me money. I don't recall ever saying that.
I didn't ask whether you ever said that. I said, did he owe you or did he owe you money in the past?
No, he didn't owe me money.
And so he steered this contract to you, to your office, and you weren't really talking to him? You hadn't talked to him for 2 years?
The contract was in 2021. I didn't leave until 2022.
So you didn't talk with him that whole time?
I left in 2022. I haven't really spoke to him since 2022 is what I stated. When I left June of 2022, around June, August dates of 2022.
Other than one last question, other than your attorney, who did you speak with today about giving testimony in this case today?
I spoke to my attorneys, Charles Graham and BC Chopra.
And I have nothing further, Your Honor.
All right. And again, I'll just double check to make sure. Did Mr. Cromwell ever join us by Zoom? Do we?
Still having technical issues. He did email me saying he has no questions. It appears that all relevant questions were asked.
All right, thank you. So just for the record, Mr. Cromwell has been apparently watching the proceeding. He had waived his client's presence and didn't have any other questions as well. So turning it over to Mr. Abadi.
And I have no questions.
All right. Mr. Bradley, you can step down. Thank you, sir.
Judge, you want these exhibits?
Yeah, I'll take this one. They're not-
May I be excused?
I hope that means this is over.
And what, just by way of proffer, what about the text?
Just to admit, so when other people asked about the text, some of them were in the record today, so I organized them. They're the ones that have been talked about today, so I just organized them. I just wanted for point of reference to have them.
She should have organized
Okay,
that before she got there.
And do we need Mr. Bradley for that?
I don't believe so, but
Have you marked them?
yes,
Have you showed them to the state?
I gave a copy to the state, but so these
Mr.
are.
Bradley, just hang on just for 1 second, just to make sure.
I'll give you all of them. So.
Admitting all of them?
She's just not organized. Now,
And while he's looking at that, Mr. Bradley handed
Absolutely,
me
Al.
Defense Exhibit 23, 24, 25.
Judge, I didn't realize that they were in my folder.
Oh, is that from the hearing? From on Friday? All right, well, thanks for returning those. Let me make sure.
Is he making his determination today, or do we have to wait for that again?
Okay, so I've got 23, 24, 25. Anything else in your binder? All right, good. Okay, and have we come to any conclusions on, what, I'm sorry, how did you mark it?
I marked it, I think we're up to 39, surprisingly the same.
All right, Defense Exhibit 39 is tendered and admitted without objection.
Well, no.
Oh, I'm sorry. Oh, okay.
Text messages that weren't referenced today with, or confronted, with,
Okay.
as it relates to Mr. Bradley.
So these are additional text messages, Ms. Merchant?
Yeah, so what I did was they objected that they weren't complete because like the first part of the text wasn't there. It was just like, oh, there was something before that was said. So what I did was I spent this whole time trying to line them up so that I had the beginning of the text, the middle, based on their objection. They have all the text. They can admit all of them if they want them complete. And
All right, how about, I'll just do this. Just, I understand the desire just to have the complete text chain, just for purposes of completing the record. I think that there's no point in having him sit here and authenticate every single one of them. So I'm willing to admit it as a court's exhibit. And only the exhibits, though, that had been previously tendered or referenced in testimony would be ones that actually are relied on for making any findings. But just so it's on the record, we have the complete text chain, should that ever be an issue for some reason. Any thoughts about that, Mr. Abadi?
My only thoughts are this is not the complete text chain. I was
Yeah.
able to briefly look at Ms. Merchant's phone when she allowed us to have it for a
Okay.
couple of seconds, minutes, and there are text messages I know that I saw that are not in what is purported to be State Exhibit 39.
Okay, all right, Ms. Merchant, what about that?
I let them take screenshots of the ones that they thought weren't there, and he sent them to himself on my phone. I have also offered to hook my phone up to whatever it is. My phone's an iPhone, his is an Android. I can't download like you could in a normal text. I told them if they had a system to get all of my texts, they could have every single one of them.
We can definitely do that.
Your Honor,
Yeah, Mr. Rice.
text that she's submitting now and tendering into evidence, they are specific parts of the conversation. The entire text chain isn't a continuous conversation, so 601. Those particular parts, given the witness's testimony, should be admitted as substantive evidence of prior and consistent statements with this testimony today. So it would be up to the government and the state if they then want to introduce the rest of it. Have at it.
Yeah. Sure. I think that's a fair point that if he had been confronted with a particular text, that could have been the opportunity to admit it as a prior and consistent statement for impeachment. And some of them were, but apparently some of them were not.
I'm taking those out. So I'm taking out the ones that they said he wasn't confronted with, and I'm just going to admit the ones that he was confronted with. That's fine. It just makes it more confusing, but it's.
All right. So we have a newly marked, newly compiled 39. Let's see what the state thinks of that one.
I wonder if
All
it
right,
is,
regardless, if that's now what is being discussed, again, I don't see a need for Mr. Bradley to be here any longer, so I'm going to excuse him at this point. Thank you, Mr. Bradley.
Judge, may we be?
Of course. Take care. Yes, that's right.
I'm wondering again, and it may be naive of me to figure if he is going to make his ruling today, which would be outstanding since this circus has been dragging out for so long. It would be awesome to know. We're coming up on March 5th. I think it's the 5th. And they're going to be voting out there, I think. I think it's the 5th. So it'll be just great to see where he's going with all of this, simply because in my impression, everything that we have uncovered that has been public would be tantamount to the interference in the 2024 election on the part of Fulton County, as well as the White House, based on some of the information that we've just shared recently. And by that, I mean the placement of Mr. DeSantis there in Fulton County, and his
So-
So where are we
significance
with Defense Exhibit 39?
in
Might be helpful.
in Washington
Talking
as a
about what I
whole.
confronted him with all of these. Right, I know. So exhibit 26, I put in so that.
So for us to find someone of his caliber working
Sure.
in that capacity there in Fulton County is really abnormal when you consider he outshines almost everybody there in Fulton County. And by he, I mean Mr. DeSantis. And as Mr. DeSantis has worked with everyone from the Clinton administration for the past several years, he's worked with large, big names in politics. I just find it quite curious that someone like that would be in Fulton County. And if he's there, there has to be an expressed purpose. Another thing that needs to be, tied together is the visits that both Fani and Wade made to Washington, D.C., the White House in particular. These are things that allow me to make the statement that I just did when I said that that is tantamount to election interference.
Just were from him in between Ms. Merchant or the context of him. I think that's the problem. When you don't, for example, if the state was to provide, I guess, just a specific text chain from a cell phone extraction, there would be an objection because the state would be making the determination as to what is relevant.
What do you
Really, all
guys
the
think about
information
that?
should be turned over, and it's for the parties to object and Your Honor to determine which parts of the conversation are relevant or not. I don't have all of the conversation. The conversation starts in September, and then so there's a few text messages from September, and then we jump to January. Ms. Merchant has determined that jump in between is not relevant. That's not appropriate. It's for Your Honor to determine what's relevant and not. And I can't make an objection as to what I don't know. I can tell you what I've read. It seems as if there are definitely parts that are missing that would make certain parts of the text message she's attempting to admit that she didn't confront the witness with would be my objection. But only the relevance can only be determined if we have the full chain. So she's determined which ones are relevant. That's your job.
Sure. So didn't she just try to do the full chain as an exhibit just a moment ago?
No, we don't have the full chain. The full chain is text messages that begin in September and continue down. That's not contained in that entire package. They're on her phone.
Okay.
She'd like us to do it in extraction. That's just that chain.
All right,
We have to do
Ms.
that with
Merchant,
technology.
and then I'll, Mr. Gillen.
Yeah, not a problem. And I offered that when we were here before, and I was told we didn't have that technology. But let me just go through them one by one. It might be easier. I was trying to just.
Oh, please don't
You
do
can just
that.
hand them to me.
So the first.
Just hand them to me. I can read them. And Miss, and
I marked them all separate.
while I'm reading them, Mr. Gillen, what did you have to add?
Great point, Your Honor. Apparently, Ms. Merchant has allowed the state to take screenshots of what they now contend will be the larger perspective on, and I disagree with them about the rule of completeness, but it's their job when something is admitted that if they have an objection because the context is not appropriate, they then move. And the state should move the rule of completeness, the admissibility of the other emails chain that they had. So the real issue here is their failure to comply with the rule of completeness once they have the material from the last hearing that they could screenshots of.
Well, isn't that what he's doing now? Because now they're being tendered?
I don't think that he is. I mean, it seemed to me that what was happening here is this Ms. Merchant had tried several different ways to get it in. She wanted everything in, and they objected to that. And she wanted the segments in that had been, the witness had been asked about, and that's what she's trying to do. My point is that if they're, at the time of frankly, of moving under the rule of completeness is at the time of the tendering. If they want to tender something to show that it should be included to be complete, that's on them,
Sure.
not on Ms. Merchant.
All right, Mr. Abadi, last point here.
So I had a very limited time with Miss Merchant's cell phone. I only had time to literally find one part of the text message to then send to myself before Miss Merchant demanded her phone back. So I did not have the opportunity to screenshot every act or every missing part of the conversation.
Are
So that
they
it
seriously
was Mr.
arguing
Gillen
this?
is saying that should be done, but it can't be done if I don't have the information. So you don't have the complete packet, and There are many of the text message screenshots that you have printed out that were not used to confront Mr. Bradley or refresh his recollection. So they're inadmissible evidence. If anyone missed the opportunity, it was the defense counsel
Sure.
to confront him.
All right. I don't think we need to go back and forth any further. Ms. Merchant, you've offered, you said, to print out a complete chain of every text exchange with Mr. Bradley since you began corresponding with him. I'll give you the chance to do that, and you can follow up by email with that exhibit. It would be the complete chain without any deletions or removals, and we'll have that marked as Defense Exhibit 39.
Judge, I
And-
have got to respond though. In court
There you go.
Friday at 1:57, when Mr. Abadi texted himself the screenshots, I literally wrote him, "Do you want any other screenshots? I have nothing to hide. You can download my phone if you want." So
All right, we're done. Okay, so I'll wait back to hear from y'all on Exhibit 39. And is there anything else to take up before we discuss Friday? Just kind of throwing it open to the floor. Seeing none. I believe I'd asked and put it out there among defense counsel to be considering how they would like to organize their arguments on Friday. Has there been any decisions reached on that?
we have a meeting tomorrow to determine that,
Okay.
and I can email the court when we're done with that. But we are going to make it as efficient as possible and break it up.
Break it up in terms of like subject matter or something like that?
If there's time limits.
Yeah.
imposed on the defense at large,
Yeah,
let
that's
us know.
that's the idea.
Okay. Tell us what that'll be, and then
Well, I'll start with, what is it that you're asking for? We'll start there. Just kind of curious.
that's an interesting.
Well, I don't think
Yeah.
we can answer that right now. Number one, the court said, look, if you divide it up, then we can go with that. Or if you can't divide it up, then I'll give each defense counsel a specific period of time. Tomorrow, we'll find out when we meet whether or not we can divide it up in a way that serves the interest of our respective clients. Hopefully we can communicate with the court.
Okay, I'll just wait to hear from you. To the point of, I think the state recently filed their own motion to, I think it formally said to reopen the evidence as to another witness. I only got to read it very briefly, or I don't know if that was just saying in the alternative, we'd like to reopen the evidence. I don't know, maybe someone can clarify that, but my thought there and what I think we ought to do Friday and what I would like to do on the issue of the cell phone analysis and this other affidavit filed by the state today is that both parties, any party rather, can make whatever arguments they want based on a proffer, any counter arguments they want to make based on a proffer. They would not be admitted into evidence at this point. And at this point, I need to start hearing the arguments in the law and what we've heard so far. And if I think I'm able to reach a ruling based on that, I will. However, if I think that the proffer is going to make a material determinative point, we can reopen the evidence at that point. But just the bottom line is on Friday, I do, the intention is that we're still sticking with argument, but the parties are free to address some of these issues that have been brought up post-hearing if they'd like to.
You haven't-
Your Honor, excuse me,
Whoa,
sorry.
let me start with Mr. Sam.
I'm alive and well with a quick question.
All right.
That suggests that we do not have to have a witness present on Friday for the cell phone rep, correct?
That's right. Friday would just be argument, and counsel can proffer why they think it's significant. And if once I've heard the law and the argument of counsel, I decide that that is going to have some material bearing on the outcome, then we can reopen the evidence and have it properly admitted and authenticated and subject to cross-examination.
Thank you.
Okay. Ms. Merchant.
I just wanted to know if the court wanted us to focus our arguments on anything. If you have any questions you wanted us to try and answer.
Well, actually, I think what I'm more likely to do is more along the lines of what I suggested before, is give y'all a time block and you use the time however you think is more effective, what you think is your strongest argument. I don't, a lot has been covered, and there's a lot in the motions that weren't covered during the evidentiary hearing that I would plan to rule on at the same time as well. So I leave that to you.
All right, thank you.
Mr. Gillen?
Your Honor, I know we have other motions to hear on Friday.
Oh, we do?
I thought we did.
I just said disqualification as a whole. So if you have arguments about forensic misconduct, about anything like that,
case between Joycelyn Wade and Nathan Wade stand as of today? Where does the divorce case between Joycelyn Wade and Nathan Wade stand as of today?
As of today, we have a settlement, a consent order incorporating a settlement as to temporary alimony and temporary attorney's fees.
To somebody who's not an attorney, what does that mean?
So it's, in any case, it's not unusual for us to set up temporary financial arrangements in a case. What's unusual about this situation is that it's been over 2 years and we're just now establishing a temporary.
This is the full interview of the attorney for special prosecutor's estranged wife. The last comment that I put on the screen raised a very good question that somebody wanted to hear what she said or how she felt. This is her attorney and she is a beast.
Financial arrangement, temporary support for my client who is not the earning spouse. So, and that's because of how this case has gone. But it's a normal part of the process. What's unusual is that it's taken this long.
You're a divorce attorney. How long have you worked in family law, in divorce law?
I've been in family law since 2003.
Have you ever handled a case quite like this one?
No. No, well, as far as the facts go of the case, there's not a lot unusual about it. The circumstances surrounding the case, that's what makes it unusual.
Elaborate on that a little bit for me.
Well, when we started this case, when Joyce Wade hired me, we had no idea about any of the circumstances surrounding the case. We certainly had no idea that Nathan Wade had accepted a position as a special prosecutor. So from my perspective, I was approaching it like any other divorce case. I had a wife who'd been married for almost 25 years to a husband, a apparently successful attorney. So we were going to undergo discovery and all the things we normally do. And then as we started to peel back the onion and questions weren't answered and things didn't make sense, that's when it turned into something else.
You mentioned that when you came onto the case, it was your understanding that you didn't know that Mr. Wade was working as a special prosecutor.
Correct.
There have been people who've caught that. You mentioned it in some filings seeking additional discovery materials over the more than 2 years now that this case has been proceeding. And there have been folks who've wondered how that could be. So I just want to put it to you, why didn't you know that Mr. Wade was a special prosecutor until at least somewhat fairly far along in the process?
Well, I can tell you that to the extent that it was public knowledge, it wasn't in any public circle that I was a part of or that Joyce was a part of. And we did not actually learn that he was the special prosecutor until around the time that the indictments came out. And in discovery, we ask about sources of income with specificity, and the answer that we received repeatedly was Nathan J. Wade, PC. So we didn't have any information, objective information that would tell us anything about that until it became a source of public information. And that's when we started down the hole of trying to get information with regard to his income. Those were the things that weren't making sense. He didn't seem to have very much in the way of income, but he seemed to have a lot of money at his disposal. And when we learned this, that's when we started doing subpoenas to Fulton County and open records requests to figure out what on earth is going on.
You mentioned something that I want to kind of circle back on, open records requests and the subpoena. I think the divorce case really got dragged into the national spotlight when you subpoenaed Fulton County District Attorney Fonnie Willis to sit for a deposition in this case. And I want to spend a little bit of time talking about that. And let's start here. DA Willis tried to quash that subpoena. There was a hearing. The judge stayed the subpoena at the time. Before that hearing, DA Willis filed a motion in response trying to quash the subpoena. And she wrote that your client was using the legal process to harass and embarrass the district attorney. And I'm quoting here, she said in her filing that doing so was obstructing and interfering with an ongoing criminal prosecution. What did you make of that when you read it in her filing?
I was astounded that she would make that type of assertion against an individual, another member of the bar. I understand intellectually what she was trying to do, but I don't take too kindly to people threatening my clients or myself. And that's what it felt like to me. It went too far.
You took it as a threat of criminal prosecution.
Correct. That if we proceeded with this deposition, that we would be prosecuted criminally for it. That's how I took it.
Did you raise that concern in a response filing of your own? Did you ever hear a response from DA Willis?
So the purpose for me sharing this with you guys is because this is very telling. This interview sort of went under the wire. A lot of people may have seen it, but it went under the radar. This is Nathan Wade's estranged wife's attorney speaking of the timelines, which if they had just focused on this, and I would have hoped brought the wife in to even, identify when she found out, when Fani and her husband started seeing each other, that would have opened up a whole can of worms. Don't forget the main purpose of Fani Willis going after the wife, stating that she was going to be, intervening in a trial or in a case. That this was a very pivotal reason for her saying this. Fani knew that if the wife got up there and had her to speak in their divorce proceeding, that she would have to tell the truth, because now she would be faced with the wife who had a timeline, a firm date of when she found out that her husband was dealing with her. Now, why do I say this is important? Because it gives some credence to the questioning that was done earlier today as it related to, was it at municipal court that they started dating, or was it when he was in, a different court? When was it? Because that speaks to the actual wife's testimony, what she would be able to say. And so what he did, and by he, I mean Wade, he ran in and he settled the portion of support, because as long as he and his wife were going through this divorce, unbeknownst to any of us, he had not been giving her any support. As a matter of fact, there were reports that showed his bank account had been in the negative, and the wife did state that he started then going into her bank account. And because he did that, her accounts were overdrawn. Please do not forget that prior to him becoming this special prosecutor, there have been news articles showing that he had as little as $2,000 in his account. So listening to her, this attorney, is very key, and it answers almost every question you may have asked.
About that? Let's talk about the subpoena specifically. You wrote in a motion, and this is where we have to peel back a little bit from the legalese as best we can, although, we'll hash it all out. But we want to be sort of as clear about all of this as we can, because there's a lot of motions and counter motions. And,
Oh, yes.
and that's the nature of these things. But you wrote in one of your motions.
Let me also state that I don't think that the Biden administration was aware of all of the underpinnings in these people's personal lives. Now, whether you know it or not, in just great fashion, the boyfriend that the father referenced 2 weeks ago, his name was, I think it was Deuce. He's now come forward on a social media campaign. So there's a lot of things that I don't think they looked at when they chose these two individuals to do their bidding. And that's the way that I see it personally.
In support of the subpoena to get DA Willis to sit for that deposition, you wrote that you wanted to depose her to gather information about the nature of the relationship between DA Fani Willis and Nathan Wade. And in that filing, you wrote that it was your belief that the two of them were engaged in a romantic relationship.
Correct.
What kind of proof do you have to support the notion that Mr. Wade and DA Willis were engaged in a romantic relationship?
So let me say one thing about the subpoena. When we first issued the subpoena, we didn't list the reason for the deposition, and we did that on purpose. It was only after her filing that when she demanded to know why we were going to ask her questions, that we reissued the subpoena with that information on it. I just think that, I just want that out there. But we received documents, like I said, I did the, sorry, I'm jumping around. I did the open records request. This was late fall. And once I received those documents, I issued a formal subpoena for evidentiary reasons. And I received those in November. It was shortly, as soon as I received those, we filed a motion for a temporary hearing because I had information about money. I did not have information about a relationship at that point. And it wasn't until we received a handful of documents from Nathan Wade on the Friday before Christmas, December 22nd, that I had information that indicated with a reasonable degree of certainty that there was definitely more than a boss-employee relationship between the two of them.
When you say information, help me understand what that is. Because the natural question of anybody who watches this is going to be, okay, but what was it? So you say you obtained information. What information did you obtain? What proof did that show to you that there was a relationship between DA Willis and Mr. Wade?
I received documents that indicated, as you've seen, that they have traveled together, ostensibly not for business purposes. I can't think of a business reason for them to have gone to Aruba or to Napa Valley. And we've issued subpoenas as a result of those documents that we received from Mr. Wade that have gone further.
When you say gone further, the latest that I've seen in the public record so far are the exhibits attached to your response to the emergency motion seeking to quash the subpoena by DA Willis. There were purported credit card statements in there that showed some flights booked for both Mr. Wade and DA Willis. You say that you've obtained new information that goes further. Can you elaborate on that?
I don't know if I should at this point. We have, let me answer it this way and tell me. We have issued subpoenas based on specific items contained in those documents, and we've received information back that gives more detail with regards to what we learned in those credit card statements.
Can I actually show you, and maybe you can help me understand the credit card statements better? I have them here. And sometimes I'm a visual learner sometimes.
Absolutely.
And one of the things that I noticed is that the credit card statements themselves show flights to San Francisco and Miami booked on behalf of passengers named Nathan J. Wade and Fonnie Willis. But you, in your filing and in our conversation here, have also mentioned trips to Aruba and other places. Can you point to where in these credit card statements those pieces of evidence come up?
I don't think that the Aruba trip is actually in these credit card statements. It was a part of the cruise that they went on, the Royal Caribbean cruise that's in here. They flew in and out of Miami, and from Miami they flew to Aruba.
Okay. And it's your belief that that was a romantic getaway?
Yes.
Did Joycelyn Wade have a sense that, I can take this back from you. Did Joycelyn Wade have a sense that this was happening?
She did not.
One of the things that some folks have asked about, and I want to make sure you have a chance to.
Before he goes into that, I think it's important to note this. His question was, did Joycelyn Wade know anything about this? No, she did not, was the answer. So that means that she didn't know they were taking any trips together. But let's just say that in order for her, prior to knowing about the trips, to even have this woman added in the mix, she knew about the relationship. I'm wondering if the other witness that they are speaking of that's supposed to be coming in on Friday is the wife. Because for the judge, that would answer a lot of questions for him. That would actually take a load off of his shoulders. He seems to be a young man that, you know, wants to do the best job that he can. He's young enough to have a long career ahead of him. And unfortunately, if he decides that he wants to start dipping in the pool of water that makes him marred or the murky waters, he's going to have a hell of a life ahead of him because they're going to use him every chance that he gets. And if that's who's coming on Friday, which we don't know, I don't know, I'm just speculating, guessing, that would be a heck of a load off of his shoulders. Please keep in mind that this video that we're watching right now came out right before Nathan Wade decided to give the wife the money, which is all he had to do in the first place. So let's just go on ahead and let's hear the answer to the question he's posing.
Elaborate on it however you choose. There's a timing question. So the subpoena to DA Willis to testify in the ongoing divorce case came on January 8th of this year.
Hey, Wanda.
On the same day, a defendant in the ongoing criminal case in Fulton County filed a motion to disqualify DA Willis, also alleging that DA Willis was engaged in a romantic relationship with Nathan Wade. So on the same day, two separate allegations of the same romantic relationship. There are those who've wondered whether you coordinated efforts with anybody who's seeking to disqualify DA Willis from the criminal case in Fulton County. To those people, what would you say?
I would say absolutely not. We didn't know about a potential romantic relationship between Nathan Wade and Fonnie Willis until immediately before Christmas.
Okay.
When we came back
Okay.
after the first of the year, we prepared and issued
So
the
they did
subpoena.
not
We were
have any
actually trying to
idea.
serve her the week before, and we were not able to perfect service. We finally perfected service on the 8th, which I understand. I've learned since that because this question has been asked of me, that apparently that was a deadline in the criminal case for filing motions. I had no idea about that.
Okay, so this is good to note. The wife didn't know. They had no clue. She sort of made herself pop up when this thing came up. By she, I mean Fanny. I do want to see if this is going to go into the information that's surrounding the, oh goodness gracious, it escapes me now. Let's just continue and maybe I'll think it up and stop again. Hold on.
Coordinated effort. What I can say is that adultery is not only a grounds for divorce in Georgia, but it's also a factor that the court considers in equitable division of property. So as soon as I received information indicating this potential relationship, I went after it. As for other people and the timing of when they did, what they were looking at, and where they got their information, I can't speak to that.
A total coincidence.
I don't generally believe in coincidences, but in this case, it literally happened on the same day.
How has this case impacted Joycelyn?
So Joycelyn she is an incredible woman. She's kind, she's sweet. She has some health issues that have gone untreated because she has not had access to resources to take care of herself. And needless to say, in the last few weeks, as all of this has gone on, it's taken a definite toll on her. She's definitely struggling.
I know the terms of the consent order have not been made public. Is Joycelyn satisfied with the current outcome of the case? And I, that's a strange phrasing to say current outcome, but this is not a final disposition.
Correct.
Is she satisfied with where things stand now?
I think that I can, without revealing any confidences, say that yes, she's very pleased with where things stand at the moment.
Can you share anything about the terms of the current agreement?
Beyond the fact that we established temporary support and that Mr. Wade is paying attorney's fees and litigation expenses, I can't.
Do you have a sense of when a final disposition will be reached in this case? It's been a 2-year-long process now.
Nathan Wade has a list of documents that he has to get to us. And after we receive those documents, we are going to try to mediate the case within 45 days. And if we are not successful, then we will proceed to the next phase of litigation.
I want to circle back to kind of where we started here. As you jogged something in my mind there when you mentioned kind of the 45-day time frame. As of this point, DA Fonnie Willis has not given sworn testimony in the divorce case, correct?
Correct.
The most current order on the matter is a stay from the judge in this case.
Yes.
Do you foresee a scenario in the future where you would renew your efforts to get the district attorney to testify?
I do foresee a scenario in which I would renew those efforts.
What would that look like? What would require you to get to that point?
So the next step, the judge wants to hear testimony from Nathan Wade. The next step, if the efforts in the next 45 days or so are not successful, would be to depose Mr. Wade. And depending on the answers that I get in that deposition, I would then make a determination as to whether or not to proceed with revisiting the issue of the deposition of DA Willis.
You say depending on the answers you would get in that potential deposition, because again, if the 45-day mediation works out, there will be no need for that, correct?
Correct.
If you do get to a point where you pursue testimony from Mr. Wade, what information from his deposition would lead you to then seek more testimony from the district attorney?
Oh, I have a lot of questions.
Yes,
for
Wanda.
Mr. Wade about his relationship with DA Willis, and more specifically, how he has dissipated assets as a result of that relationship. That's very relevant to what we need to deal with in the divorce case. There's a reason that I subpoenaed DA Willis before taking or trying to take Nathan Wade's deposition. And the reason that I did it in the first place is the reason that I think I'll need to ultimately.
And what is that reason?
Nathan Wade has not been forthcoming in this case. And we have jumped through hoops of fire to obtain the most basic information from him. Sometimes he has been, in my view, outright deceptive. And other times he's just playing games with information. And I wanted to go to a source that I had a more reasonable belief might possibly tell the truth.
I want to end with 2 final questions for you. And I guess let's start with this one. Why, this is your first sit-down interview on this matter. I know you've spoken on the courthouse steps. I saw that interview. But this is the first time you're sitting down and having an extended conversation about this case. Why talk about it now?
Listen carefully.
I think that there's a lot of misunderstanding out there on many levels with regards to this case, what's gone on, what's going on now, what can be expected in the near future, even so far as there's a misunderstanding as to what the agreement yesterday was. And so it's important to me that the facts are clear and that the record is clear, not to talk in legalese.
And speaking of legalese, I want to circle back to sort of the core component here one more time, just so it's crystal clear where your perspective is, because it has been a complex case. It's a long case. It's a big docket. Even for folks who are in the profession, I think they would say that this is a complex matter with a lot to track. The biggest question that surrounded all of this has been proof, has been how do you prove these allegations? And these are serious allegations, that there is a romantic relationship between an elected official and somebody involved in both a long-term divorce case and a very high-profile prosecution. So I just want to put it to you one more time as clearly as possible. What proof do you have to support the allegation that DA Fonnie Willis and Nathan Wade had a romantic relationship?
I'm not trying to be slick. I have documentary evidence that suggests to me that they absolutely are engaging in a romantic relationship. And I wouldn't be pursuing this line of question, this avenue of investigation, if I wasn't reasonably certain of that fact.
I notice the tense you use there is are engaged. In your view, this is an ongoing current relationship.
Yes.
I always say last question, but then something comes up. So I just want to.
We do in court too.
I know. Well, you want to make sure. It's important to us that you have every opportunity to respond to anything and everything.
Right.
It comes down to a fairness issue. And so you mentioned you wouldn't be pursuing this line of questioning if you weren't reasonably certain of this. There are those who have said that. Why does this matter? It's tawdry. It's salacious. Why does this matter? Why does a potential relationship between these two matter to your case? To people who ask that question, what would you say?
I would say what we just discussed a moment ago, that adultery is not only a grounds for divorce in Georgia, it's also a factor for the judge to consider or the court to consider in equitably dividing assets. The fact that it's become salacious, it's always tawdry in every case. The fact that it's salacious, I think, is because of the specific people involved in this case, which obviously we had no control over. But we need to figure out what's going on, and really, probably even more importantly, figure out what portion of this estate has been lost as a.
Now, what's on the screen is she should sue the mistress for alienation of affection. Unfortunately, Georgia outlawed that a while ago. Now, it can still happen, I believe, in either North or South Carolina, and I believe that it can happen in Mississippi, but it can't happen in Georgia anymore. Boy, wouldn't that have been awesome for a lot of people.
The result of this relationship. And that's where it really becomes relevant.
So it's about the money.
Well, at the end of the day, the judge said it. It's a math problem. And so ultimately, we are going to have to bring it down to numbers. But there are factual issues to discuss. A 26-year marriage, a stay-at-home woman. She worked while he went through law school. The fact that he's having an affair and doing some of the things that he's done before and during this case is highly relevant. And we have to go into that.
You mentioned the times you felt that Nathan Wade was being deceptive, outright deceptive, I think was the language that you used in the efforts to obtain information from him. It seems particularly about financial information. Describe those deceptions. What are the concerns? What are you looking for, and what are you worried is being hidden?
So I'll give a couple of examples. It's all a matter of record. We issued a notice of deposition, request for documents to his firm, Wade Bradley Campbell, and we received no response. Nathan Wade was the registered agent for Wade Bradley Campbell. No response. Wade Bradley Campbell was representing Nathan Wade in the beginning of this case. And they were the ones that were putting out these discovery responses that were completely barren of facts and information, basic information. The fact that we had to find out by watching the news, no offense, that what his current job was, it's ridiculous. And we learned it 2 years almost after this case had been going on because he wouldn't disclose it. He knew the information. He has a duty to seasonably supplement his discovery, and he just wouldn't do it. He kept producing the same handful of documents that he knew didn't tell us what we needed to know. And as far as questions, he's answered questions in a way that I do not believe are truthful.
Mr. Wade's been paid, according to public record, hundreds of thousands of dollars for his role as a special prosecutor in the ongoing criminal case against former President Trump and other co-defendants related to allegations of 2020 election interference. Mm-hmm. Are those payments at the core of what information you're seeking? And forgive me to be repetitive on this, but I want to make sure we drill down as much as possible into the core details here. And I don't want to put words in your mouth either, so I want to frame this carefully. But are those payments, are those payment records what you're seeking most of all?
That's a piece of it that we've been seeking. Payment records, tracking the money. They say always follow the money, and that's what we've been trying to do. Follow where it's been going and what accounts it's been going into and where it's ended up. And that has taken a fairly Herculean effort because there's a lot of inconsistency with what's happened with the money.
You feel that there's been an effort to hide how much he's been paid?
In this day and age, it's very difficult for people to hide money, given the technology that we have. But I do know that he has been putting money in places that it would seem to me that he is trying to shield it from discussion in our divorce.
Is there anything I missed that you think is important for people to understand about this case and about your role in it?
Honestly, I know that there are all these questions about coordinating and that sort of thing. I'm here to do a job for Joyce and to protect her. If there's anybody that deserves it, it's her. And we're not connected with the other case. We are seeking similar information about the same people. but for different purposes. And it's important to me that people understand that. I think that Joyce has gotten a lot of criticism for this belief that she's working with others involved in that prosecution, or that we are. And that's just not what's happening.
Well, I thank you guys for hanging out. Thank you for hanging out with me. I really appreciate you for allowing me to indulging me to share that last video with you. I found it very important because it sort of let us see her side. And she's been such a lady in that we haven't heard her trashing anybody. Her daughter hasn't been trashing anyone. The only thing that I think his wife has been trying to do is get herself healthy and to get everything taken care of. Now, there was a statement that her attorney mentioned when she said that there were some things that was said about her client that were just flat lies or that didn't have any substance. And that was the rumor that's been going around that everybody and their mama has been using actually to validate everything that Nathan Wade has done. And that is that there was a relationship allegedly that happened in 2015 between his friend and her. That is what he has said. But let me just tell you that in all of my life of counseling and talking to women and talking to people dealing with relationships, based on the fact that I've had real raggedy ones in my life and I've gone through a lot of crap in my life, what I found is there are a lot of people who will project. And when they do that projection, they'll project what they've been doing onto the other person that may have found out that they were cheating, right? So Bob finds out that Betty's been cheating. And then what Betty will do is she'll project what she's been doing onto Bob, if that makes sense. And even if she doesn't have any proof, and if she doesn't have any, if there's no proof, if there is nothing that shows that's really going on, she fabricates it in her mind and uses that as the springboard to stand on to gain faith from those around or to gain sympathy from those around. It's a part of the narcissistic look at me piece in tandem with the liar piece. People who are just constantly a chronic liar, they just lie for nothing. Sometimes those individuals can believe it and believe it and believe it and say it until they just have given it legs and it runs on its own. That's what's possibly gone on here, not knowing them and putting my feelers out to people who live in Atlanta. That's where I used to stay. Haven't gotten any really good concrete answers from the people that would hang out in those circles to bring back to you guys. But trust and believe, I was digging. I wanted to know. And I wanted to know because I do understand that Atlanta is one of those places where it's very possible that spouses cheat on one another. And it's highly possible that the man in this case would have been the one who was cheating first, especially when you look at how much he lies. And if he's innocent, he just lies for nothing. He lies for nothing. He doesn't need any help to lie. He doesn't need a reason. It could just be, well, I'm breathing. Let's just lie, which then takes him into the pathology, a pathological liar, which is totally a medical determination. But in my opinion, there's certainly some issues here that need to be unfolded. And I do hope that, barring all of the stuff that I think with my conspiratorial mind, because I believe, based on some of the stories that I brought you all just recently, and as I have from the beginning, that they're throwing everything at Trump right now to prevent him from even being considered a candidate because they know, and this is what the public eye is, right? Because I'm not voting for anybody. I'm just telling you what I see. And I believe that the powers that be that want to continue with the right and left paradigm, those that are in control of that, I believe that what they wanted was for this to be a complete shakedown of Trump. I believe that they wanted to put as much trash on the wall and throw as much paint on the wall that they could to disqualify him in all ways. Some would say, well, if that's the case, then how are they all the same? Hey, you figure that out on your own time. They are all the same side, same coin, different side. But in as much as there have been the Letitia James, there has been almost, I can't even count all the people that have been after this man recently. There is a reason for them not wanting him to be the candidate. Now, let's just say this. There were things that were going on when he was in office that were a sort of precursor to things to come, or a little glimpse, a glitter of things to come, which is some of the things that we're dealing with right now. Certainly, there are a lot of questions that could be answered one way or another as it relates to the border wall that didn't get complete. We could have a lot of people that can go all the way back from the time that the monies were given up in the first place for the border wall and it wasn't complete. We all have enough common sense to know that there are at least 20 levels above the cat that says the oath on to be the president. So there's a lot of stuff that we could throw into the hat. But the one thing we know for sure is this was a whole orchestrated plan that possibly did not go to the way that they wanted it to. This was a concerted effort to prevent him from running again. And what they know about him that we don't, I don't know. I mean, we've even got, some indication that the people we see aren't the people that we see. We've got that out here, floating around everywhere from TikTok all the way to, to Instagram, to Facebook. I mean, you've got all of these stories showing, Biden with this weird neck and these furrows in the forehead where they're showing it doesn't look like it's, that person or whatever. So we've got a lot of stuff that's going on right now. What I will say is to drill this down. This case is multi-pronged and it is really exposing the greed and the level that people will go to get notoriety, to get position, and to get promises of future positions, because that's the only thing that I could see coming out of this for Fani or for Nathan Wade. The fact that DeSantis is in that office in Fulton County, little old Fulton, compared to everything else that he's done, that seals it for me. That's all I need to prove that the Biden administration had something to do with this, because there's no reason for anybody with that much weight in the game. And if you don't know who I'm referring to, go back to one of the other videos that we did just, I think, yesterday. There's no reason for DeSantis to be in that office. None. This guy is miles above all of that. Having worked with the Bush administration, having worked with Obama, having worked with the Clintons, having worked with major senators, there's no reason for somebody of that caliber to be inside of Fulton County working, helping out with public relations and media. If he was not sent. So those are the things that I'm going to hold on to. I'm going to hold on to the fact that they're using a lot of Black people who are allowing themselves to be used for money, for fame. I'm going to hold on to the fact that, but for this guy being in that office, I wouldn't even have connected the dots and made it solidified that this was the Biden administration's doing. And I'm also going to venture to say that I don't think that their administration even knew that there was this underbelly of filth going on with Wade and with Fani. I just don't. So with that, I'm going to thank each and every one of you for hanging out with me. If you have a question and you want to ask, would you consider sending your questions so that I can read them? I want to start having a questions and answer day. And so if you would send your questions to info@Felicia, Felicia, Lockhart.com, info@FeliciaLockhart.com. I will print those out and we will read them and I'll answer them to the best of my ability. If you want to ask some questions of Judge Joe, please ask those questions there and I'll make sure that he gets us an answer as his schedule permits. So I want to tell everybody that I appreciate you guys for hanging out with us for the last 2 hours and 50 minutes. Time does go by really quickly, but that case was making it go really, really slow. All right, I don't know whose adult child that is riding up and down the road on that motor scooter, but nails anyone? Okay. All right, you guys, y'all take care of yourselves and make sure that when you take care of yourself, you turn around and you then pull somebody else up. Before we leave, let's give Judge Joe Brown's barbecue sauce a try. Hey everyone, it's me, Felicia, of the Lockhart Perspective and Headlines with a Voice. I want to tell you a little secret. This is what I used to do, because I don't do it anymore. I would go to the store, buy the barbecue sauce, pour it inside of a bowl, put a whole bunch of different spices, a dash of brown sugar, a dash of maple, and a dash of mustard, stir it all around, and everybody would be like, oh my gosh, this is the best, this is the best. But I was exhausted after all of that, and a lot of times I couldn't remember how many dashes of what I put in it. But I don't have to do that anymore, because now I just go to Judge Joe Brown's website and I order his 3-pack of bottled barbecue sauce. It is by far the best, and I do mean the best barbecue sauce I've ever eaten. And when you go to his website and you order his 3-pack, you'll see exactly what I mean. Head on over to jjbbbbq.com and order Judge Joe Brown's barbecue sauce. You'll be glad you did, and you're going to tell me about it. I know you will. I've always been a unique person, you know what I mean? Sort of laid back in a way, but very adamant and very passionate about what I believe. I think a lot of times that sort of throws people off because they don't expect me to have the mindset or the process of thought that I do. And so when you come in to watch my channel, you may hear a myriad of thoughts and ideas that could be different from others. What I want you to do is just sit back, like, share, and subscribe.